Commonwealth versus Benjamin Claywell.
That's a 20 it's a 15-year sentence. So we're going to start saying so getting to what he's served within 20 years. No, this is just that inflated. This is a very long time to enter in principle. He wanted to know.
Come over.
Good morning. Commonwealth versus Benjamin Claywell, 22 CR 0047. Are you Benjamin Claywell?
Yes, sir.
Okay, you were born in 1986.
Yes, sir.
Last four digits, your social security number 2415.
Yes, sir.
I understand that you wish to enter a plea today. Is that correct?
Yes, sir.
Are you under the influence of drugs or alcohol?
No, sir.
Okay, is this plea freely and voluntarily given?
Yes, sir.
Are you the same person that we just previously identified?
Yes, sir.
Is your judgment impaired today in any way?
No, sir.
Have you discussed this matter with your attorney and are you satisfied with their advice?
Yes, sir.
Viewed the evidence Commonwealth has against you, believe you're fully informed about your case. You understand that you do not have to enter guilty plea today. You have certain rights under the United States and Kentucky Constitution. Before I can accept the plea, I need to know that you understand those rights. I'm going to go over them and I'm going to inquire. Okay?
Yes, sir.
You have a right not to testify against yourself. No one can make you say anything. Your right to speak trial by jury, the right to be represented by counsel at your jury trial, the right to confront and cross-examine by witness called to testify against you, right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to a higher court if you lose, the right to require the Commonwealth proves on a reasonable doubt that you are charges, that you're guilty of charge. You understand by entering a guilty plea that you give up those rights. You understand that, sir?
Yes, sir.
Okay. I may consider the Commonwealth's recommendation, but I may apply in range of sentence provided below. I don't have to accept the recommendation. Now, I think that you are a state prisoner now, so is that correct?
That's right, sir.
And,
We cannot judge because he has been out of custody since he had his last PSI.
okay, that's what I was inquiring. Well, I will await a pre-sentence investigation report to be done by probation and parole. In the event I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence than you agreed to, you will have the right to withdraw your plea and proceed to trial. You understand that?
Yes, sir.
If y'all all move to your left over here just a bit. Just move forward, let the Commonwealth attorney. Madam Commonwealth Attorney, what is your
Yes,
understanding of the offer?
yes, Your Honor. Upon a plea of guilty to manslaughter second degree and persistent felony offender second degree, the defendant shall receive a sentence of 15 years. Upon a plea of guilty to operating a motor vehicle with alcohol concentration of or above 0.08 or while under the influence of alcohol or other substances aggravating circumstances, fourth offense, and persistent felony offender first degree, the defendant shall receive a sentence of 10 years. Upon a plea of guilty to operating a motor vehicle while license is revoked or suspended for driving under the influence third or subsequent offense, aggravating circumstances, and persistent felony offender first degree, the defendant shall receive a sentence of 10 years. The 15-year sentence and the two 10-year sentences shall run concurrently for a total of 15 years to serve. The 15-year sentence shall run consecutively to Clinton indictment number 21 CR 89, Clinton indictment number 21 CR 88, and Wayne indictment number 17 CR 54. The defendant shall forfeit $337.81 to the Commonwealth of Kentucky to be dispersed in accordance with said forfeiture order submitted with the plea agreement. The Commonwealth opposes probation and shock probation. The defendant shall receive credit for time served, shall pay a fine and court costs at the discretion of the court, and the defendant agrees to have any and all evidence in the above style case disposed of in accordance with the laws of the Commonwealth of Kentucky and the holding agency.
Is that what you agree to, sir?
Yes, sir.
Pleading guilty because you did commit the acts charged in the indictment as amended.
Yes, sir.
Are you doing so of your own free will?
Yes, sir.
Okay, now knowing your constitutional rights, I've pretty explained to you, is it still your desire to waive these rights and allow the court to fix your punishment within the range removed by law? Is it still your desire to waive the rights I read to you and allow the court to fix the punishment in the range permitted by law, subject to it being in the range that you agreed to?
Yes, sir.
Okay. Okay, now you got the documents, that's your signature on there?
Yes, sir.
Okay, I'll accept the agreement, order precincts investigation report to be done by probation and parole, and we'll schedule sentencing on May the 2nd. So if you got the travel documents, do you have the travel documents? You present them over here. Bailey, you fill that in. Well, he'll need to be back here for sentencing on May the 2nd.
Judge will get a transfer order to you for that day. It's just.
Usually they have a little thing for me to sign. Okay.
Come on, person.
Thank you very much. Daniel Morland. Daniel Morland. Commonwealth versus Daniel Morland, 08 CR 0079 and 08 CR 0078. Are you Daniel Morland?
Yes, Your Honor.
You born in 1987?
Yes, sir.
Last four digits, social security number 9809. Mr. Stockton's on the docket as a status here.
Yes, Your Honor.
You want to come around and explain?
Yes.
You step just a little bit to your left. Thank you.
I think it really should be on for sentencing, Your Honor. The way I read the Supreme Court opinion, he has to be resentenced. And the way I read, and I filed a brief from the file, that the judgment was valid, but the probation provision was void and that was separable. And that I'm just asking the court to sentence him to the full amount that he agreed to. And if he doesn't want to do that, he has a remedy. Just like any other vote.
No trial.
That's correct.
You want to get behind the podium here.
And Judge, first procedurally, and I know we attempted to do this in Mr. Morland's absence last rule day. I know that DPA represents Mr. Morland in the appellate portion, but I'm not certain as to for this portion, if Mr. Cross is still not attorney of record.
Well, you're appointed now. So
Okay, that's,
that's it.
Your Honor, I'm through years
Okay. Well, don't worry, I just took care of it.
and So Judge, I wanted to start there procedurally. Second, in my reading of the Supreme Court decision, before sentencing, what it also contemplated is allowing Mr. Moore the opportunity at a fair negotiation, both him and the Commonwealth. Particularly, that was right before the conclusion in the opinion. Judge, what I would be asking, and I know we're very quick on a rule day coming up. Judge, I would ask to have Mr. Moore the opportunity to, if he wants to, withdraw his plea and.
Well, here's the deal. He's not represented presently by counsel on this, you just informed me. So I think it would be unfair to him to take any action on this today. So I'm appointing you, considering his incarceration period that he's had, that sort of thing. I'm appointing you. Now, can you be ready for this by May the 2nd?
Absolutely, Judge.
Okay, we'll reschedule it to May the 2nd, and I would appreciate, Mr. Stockton, if you want to take a look at the brief you previously filed in this or whatever and kind of.
I just disagree with Mr. Pennington.
Well, I know you do, but I'm just gonna give you the opportunity to refresh that if you want to, or you can stand on
I
it.
understand, though.
And you want an opportunity to respond to it, and then you respond to, you file something within 15 days, and that,
I'll respond.
if you want to reply, you can. Okay? You all have a document, don't you?
Hold on. And Judge, Mr. Morland did, and I spoke to him briefly before the court. He did want me to ask if the court be inclined to allow him to stay in Albany at the Clinton County Detention Center.
Now, listen, I don't have any control. That's a separate branch of government. You know.
Maybe, Judge, I just was shooting a shot, Judge.
Well, I know, but I have no control over the executive branch. They have very little control over me. We all coexist.
I understand, Your Honor.
Okay.
And I'll tender those transport orders by the end of the week.
Now, where's he located? Back. So you don't need to go up there and see him, is that correct?
I can do it.
Okay, well, thank y'all very much. Safe travel. Colton Abson. Commonwealth versus Colton Abson. Are you Colton Abson?
Yes,
You born in 1998?
yes,
Last four digits, so number 4431.
yes.
Here to a pretrial conference. Y'all move to the left. What's the Commonwealth going to say? Mr. Stockton?
Well, we don't have an agreement yet, and I don't know if we're gonna have one or not.
We're getting it done. I just don't have those documents.
Okay, I'd ask for one more negotiation day. It's
What is the charge?
Mr. Abs, it's an assault, there's an issue at the jail. Mr. Abson wants to go to the military. I think that's all right with the victims, but I've never had any luck in 20 years. Anybody ever having criminal charges going to the military? This might be a first. But all I've been furnished is he's looked into it, he's took the ASVAB test, but there's no contract or anything like that. And I want everything ironclad before I agree to dismiss these charges.
Yeah, well, we spent almost 2 years trying to get tattoos removed off somebody.
That was the last picture I think we had.
And it didn't work out so well.
Yeah, so but we've got to May the 2nd. I'm willing to go out that far and see if we can get
Was
this.
the person hurt very bad?
No, the victim, Mr. Cross, Brad Cross, he said whatever.
Yeah. Well, what kind of bond is this young?
He's out on loan.
You know, what kind of bond?
Judge, it's a curfew bond, work, church, school. Mr. Abson's currently working 2 jobs or.
Well, let me suggest this. Why don't you dismiss this charge without prejudice?
I just wonder if anything will get done.
Well, and then if he's not done, you can present it to the grand jury. Oh, maybe today.
He's going to have some time to get things done.
Well, I mean, and then he'd have to May the 2nd.
I don't know, can you get everything done May the 2nd?
I have to get a copy of my high school transcript, my high school diploma.
Well, I don't think you can get to the diploma. You might be able to get a transcript, something like that. What kind of turnaround period, if you go and volunteer to serve your country, when will they take you, do you know?
He said when I get all my paperwork, stuff.
So you gonna get your transcript. That's at the part, out here probably. What else you have to have?
I have to have a copy of my birth certificate and a copy of my high school diploma. He said if I got all that turned into him, that they could have me, shipped out pretty quickly to MEPS,
What is pretty quickly?
probably 2 to 3 months.
Well, I tell you what, you come back here on May the 2nd to see if you've got everything else in line, okay? And get that better timeline. And if it was agreeable to Commonwealth, we'll dismiss the charge without prejudice on May the 2nd. He's got everything lined up. Is that fair enough to you?
Absolutely, Judge. And I'll work.
Okay.
We'll call.
Okay.
Thank you, Judge.
Yeah, Christy Beatty.
Morning.
Morning. Are you Christy Beatty?
Yes.
Were you born in 1974,
76,
71,
6,
76? Okay. What are the last 4 digits of your social security number?
2047.
The grand jury of, where's he now? There it is. The grand jury of Clinton County has returned an indictment against you. You're represented by counsel. You have the right to remain silent. If you have any questions, step away from the podium and ask Mr. Cross. Grand jury has indicted you charging with trafficking and controlled substance, first degree, first offense. You understand what the charge is. Okay. Mr. Dale, Mr. Cross, you acknowledge the identity of your client, proceed indictment, waive formal reading and arraignment, enter plea not guilty, reserving all pre-trial motions.
Yes, Your Honor.
I'm signing a reciprocal discovery order. The Commonwealth will be presenting your attorney information to help prepare for your defense. What's the negotiation date? Mr.
April the 26th at 9 a.m. here in the courthouse.
April the 26th at 9 a.m. You shall be here with counsel for your negotiations, and your next court day will be May the 2nd here at 9 a.m. Both of them are conditions of your bond. There's been no complaint about the bond, so you'll continue on the same bond. Okay, thank you very much. Stephanie V. Celestino. Miss Stephanie, could you help me pronounce your last name correctly?
DeCelestino.
Well, I got pretty covered. East Celestino. You have filed an affidavit, concerning your appointment. I'm gonna find that, at the present, you are indigent, but I will reserve for a later time to see if you have to pay part of the legal fee, okay?
Okay.
So I'm gonna appoint public advocacy. The reason I'm doing it, because it appears you're a joint owner of a fairly significant piece of property, but you don't have access to it now because you're separated. Is that right?
Yes.
So I'm gonna go ahead and appoint you, and then we'll take a look at it later to see if you're charged anything for your attorney. If you have the right to remain silent, you're represented by an attorney. The grand jury of Clinton County has returned an indictment charging you with flagrant non-support. You understand what that is? Well, You get it. It means that they've charged you with not paying child support the way you're supposed to. Don't say what you did or what you didn't. I just want you to understand, you understand what that means, then flagrant non-support.
Well, just like you just speak.
Oh.
Just like yes.
Yes.
You come back here at 9 a.m. here at the Justice Center on April the 26th for negotiations. See if you can work this out with the Commonwealth. And then you'll come back here for your next court date on April 11th at 9 a.m. Both of them are conditioned.
Nice.
Pardon?
Nice.
May 2nd. Today's April 11th. On May 2nd, so be here on April the 26th for negotiation and May 2nd, both of them at 9 a.m.
The
First,
26th and May 2nd. Okay.
April 26th and May 2nd. There's no complaint about your bond, so we'll let you stay on the same bond. Thank you. Haley Harbor.
And Judge, you also want to call Cody Diversion with the companion case.
Do what?
Would you also like to call Cody Diversion? He's a co-defendant.
Yes, Your Honor. So we get it right there.
Cody Perry. Commonwealth versus Haley Harbor, 22 CR 0034 and 22 CR 0039. You're Haley Harbor,
Yes.
born in 2000. Last four digits of social security number 6213.
Yes.
Okay, Commonwealth, see, I lost it. Commonwealth versus Cody Perigin, 22 CR 0035, 22 CR 0038. You are Cody Perigin,
Yes,
born in 1996.
Yeah.
Last four digits of social security number 2329.
yes, sir.
You don't want to move to the left over here. What was the Commonwealth?
Your Honor, this was the case that was set at the end of February, and we had the medical examiner amended her report. We had to continue the case.
Yes.
And I'm asking for another trial date now that defense counsel said I can't review that. And I will tell the court,
Get behind the Commonwealth.
I will tell the court, I've got to get Dr. Bondry's schedule lined up from UK. He's in the neonatal unit. I've got travel nurses that I need to track down, so I'll need some time in order to get all that together. And I was wondering, my August, I can't really set anything in August. I was wondering if we could use the trial date of the Whitledge case in September for this case, because it's settled. It was September the 9th through the 12th. Any of those dates would be fine with me. That'll give me time to have the witnesses here.
I'm tied up on the 9th, but we can start on the 10th. We need some time to, Your Honor, because we've got to.
They want to hire an expert.
Yeah.
Judge, I'm with the judge order.
What were those days again?
The 9th through the 12th of September.
10th, I'm tied up on
I
that.
know, but that was the dates of the trial was set. I don't want to start with him. We can try this.
Is the 12th of those back? Okay.
It was a murder case, so we were going to take a vote on the Thursday.
I think we can do this on the 10th.
Later, 2 days, so I think.
Yeah, it's all support.
September 10th and 11th.
Thank you, Your Honor. And before Ms. Harper leaves, I think there's one other matter, we need to get her recognized as a witness. Yes. And this may be a little complicated because I had on today, Cody Smith was set for pre-trial. And I had to file a motion to revoke his bond based on an incident with him and Ms. Harper and another assault case. Mr. Wittenberg filed a motion to continue, and I've been corresponding with his office and couldn't get any dates except for May the 2nd.
Well, it's not gonna be continued.
Okay, I just wanted to.
I want counsel today, but, you know, unfortunately, if you wait to, this has been scheduled for a while and you wait for the day before and file a continuance, it's not good enough. You know, it's not good enough. So somebody needs to contact him and tell him he needs to be over here today because it's gonna be heard.
Evidently, he's in trial in Burke County Court of his office. So.
Or so he says.
So he says.
So we'll need to verify that.
Okay. Now, can you, when we all found people, I'll have her call.
He can appear by Zoom or something today. We can get something set up. You know, there's a serious charge involved with somebody that's under our jurisdiction. There's some violence involved and they're not just gonna come in here and file something. They'll put off what not happening.
And I will say also, I've got a special, tell the Attorney General's office to get a special prosecutor in her case with Mr. Smith.
Per case, which may.
That's correct.
There is a rate tax scheduled in 1911, which is a special prosecutor.
What-
That way, the critical response on the rate motion.
All for the same.
Okay, well,
We'll find out.
you just stay around. Okay.
Okay.
Jamie Harold. Seems to be an active warrant for Jamie Harold.
That's correct. And you said that is Matthew prosecutor.
Matthew prosecutor.
Did it refer to?
Yes.
Cody Keith.
Well, that's all here.
Well, I don't need. It says pretrial diversion revocation is what it says. Are you Cody Keith, the circuit born in 1993? The last four digits social security number, 9846.
I can hear you.
9846, last four digits of your social security. What are the last?
5490.
Says pretrial.
I may need Mr.
We all move over that way.
I may need Mr. Payne to help explain this, but this is what happened. Back in July of last year, Mr. Smith was arrested driving 100 miles an hour with a child involved with a marijuana in the car. My office was never notified of that, just recently. And I think Mr. Smith, you'll have to tell me, was he on active supervision or inactive at that time?
At the time of the charge, he was on.
Raise your right hand.
Yeah.
Swear the testimony you're about to give is the truth, the whole truth, nothing but the truth.
Yes, sir.
Get behind the podium.
All right.
Stockton, get close enough to inquire.
At the time of the violation, he was on active supervision. It was missed by my office, and in November, they requested inactive for him, and he was requested, they granted him inactive after the new violation. But when our office would become aware of the new violation, they done a violation report and submitted the report to the court, and that's when the motion was made.
And was there anything that caused it to come to the attention other than the July incident?
No,
Okay.
what caused it to come to attention is we get hits in our system, and sometimes we get them really late, and we got this one late, and we done our due diligence and reported it to the court.
Now, is he on active or inactive supervision now?
He is on inactive now.
So that's the story, Your Honor. This was happening in
I
July.
understand completely.
So I don't know that I want him revoked because he's done well since he's been on inactive supervision. I think he at least ought to be placed on active supervision for a moment.
How much time does he have left on?
To September of this year.
put him on active supervision till September. Okay, now look,
I'm aware of the situation.
now I know you are. I know you are. You don't look like you're missing much, you know what I mean? You know what's going on.
Yeah, I'm aware of everything.
Okay, well, I am too.
I'm,
We're all aware,
But
we're
that's
all on the
good, I
same
guess.
page, so you just live at the foot of the cross, keep working, in September, you can have us behind you, okay?
yeah, I got turned in some, work time for him.
Okay, thank you very much. Michael Likens.
Your Honor, this is the case we have no.
Mr. Stockton. Mr. Stockton.
Just pretty much.
Commonwealth versus Michael Likens.
Your Honor, this is the case we have no service on. He's in Indiana recovering from serious illness, very serious. And I'd sent a bunch of medicals to Mr. Stockton and Megan and didn't get a Zoom link or anything to do him today. I would suggest we just pass him over to the second and I think.
I suggest that this guy has not been, he's not been arraigned.
Correct.
And I want him under the jurisdiction. I didn't see anything. I saw where there was one medication that might be administered through IV, but he's not in a hospital anywhere.
No, no, it's not.
And I will not go over on the record the various illnesses that he had, but I looked down through there. I'm not satisfied with him not being in front of the court. And I will not arraign anybody by Zoom. And there wasn't anything on there that indicated that he couldn't travel. There was not a statement, just a list. So there's a warrant out for him now, I guess, an indictment warrant. Well, I'm gonna tell you, he needs to come down here, you know, or provide a letter from a legitimate doctor that he cannot travel. And I do not have that now. Now, I don't like this. I'm sorry, he's got the medical problem, he's got, which we will be careful not to mention.
Your Honor, I've requested a letter to supplement what we got. They could not get that to us. Now, Megan, did you say this had been converted to a summons? Because I hadn't been advised of that. We talked about doing that, but you hadn't done it.
Come up and request it. Your last motion.
Yeah, I requested it, but it hadn't been done, right?
I think it's done, man. I'm pretty certain.
So it's coming. Okay, I never was advised of that, but that's right.
Well, that's why I'm a little reticent. That's the first time I've ever done that without any documentation that a person cannot travel. And I will assure you that I will never do it again, ever. Because you issued a summons and the guy still doesn't come back and he still doesn't provide any documentation. If there's not documentation in my office and on the record in 10 days, I'm going to reissue the warrant.
Understandable. It's fair enough.
Okay? And the warrant, and he shall be back here on May the 7th.
It's fine, Your Honor.
Joseph McDermott. There's an active warrant out, Mr. Stockton.
Yes, it's not been served. Out in Wayne County.
You may be on.
Okay.
Hannah Murphy. Commonwealth of Kentucky versus Hannah Murphy. Are you Hannah Murphy?
Yes.
Born in 2001.
Yes.
Last four digits of social security number 5960.
Yes.
You're here today on 24 CI 0016 for arraignment. You have an attorney. You have the right to remain silent. The grand jury of Clinton County has returned an indictment charging you with an unlawful imprisonment in the first degree. You understand what that is?
Yes.
Counselor, you acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter plea not guilty, reserving all pretrial motions.
Yes, Your Honor.
Then you come back here on April the 26th at 9 a.m. for negotiation, and your next court date is May the 2nd here. Both of them are conditions for your bond. And and sign a reciprocal discovery order. Commonwealth will provide your attorney with information they have to help you prepare for your defense and have an ongoing obligation to do so. Okay, thank you very
And
much.
Judge, if I may, just as a point of order, it's my understanding there will also be a Mr. Willis arraigned on the charge for, as a co-defendant in this case.
Yes.
I represent Mr. Willis in the district court, so I know there will be a conflict. I've already notified DPA, so that wheel is turning, but I just wanted to let the board be aware of it.
Get somebody appointed and
Absolutely, Judge.
be there on negotiation day.
Yes, Your Honor.
I get you. Thank you. Lloyd Owens. Lloyd Owens. Good morning. Commonwealth versus Lloyd Owens, 24 CI 0004. Are you Lloyd Owens?
Yeah.
You were born in 1959?
Yeah.
Last four digits of your social security number 8020.
Yeah.
You're here for a pretrial conference. What does the Commonwealth have to say?
We don't have a resolution, Your Honor.
Would you come up and
We don't have a resolution at this time, Your Honor.
what's the charge?
Oh, it's two counts of wanton danger. Allegedly wanting to gun with two people on the same day. Mr. Kraus says it's a family deal with two sisters. I think there's probably more to it.
Well, what do you want to do with it?
Well, we need
Come on
to,
up.
we need to get a trial date or get one more negotiation day because he was going to furnish me some things that I hadn't gotten yet.
I think we're going to go ahead and file the suit that I told you about, but I've got to confirm that with Lloyd today. We've talked
Yeah,
about it.
I'd like to be able to talk to the victims if he furnishes people. It's going to.
Probably good.
Negotiation day, April the 26th, next court date, May the 2nd, both of them at 9 a.m. Conditions your bond.
Your Honor, he's got a mind to monitor on. He'd asked that to be,
Well, I don't know anything about this case. There was a reason we put that, was Mr. Stockton, there was alleged potential violence here. That's the reason we put that.
I wouldn't agree to it. It's fine.
Okay, thank you.
What that's saying.
Lloyd Pryor. Troy Pryor.
He's allegedly in rehab in Tennessee. Yeah, I've got a letter. And we've also got another settlement case going to grand jury today, so I'll have to make a decision whether I'm extraditing up here tonight. Thanks for those.
Well, wait just a
See if they
second.
come. He went on April 9th, Buffalo Valley.
You want a bench warrant issued on this, or you just want to wait to see if there's?
I want the court to, when the indictment comes out, just put a summons for next month. And if he doesn't come up here and answer to these next month, if he doesn't leave rehab, then I'll ask for a warrant, and I'll try to expedite. But I will give him an opportunity, he will appear in court.
And Judge, this was the one where you had said, you had talked about him staying in Tennessee, and Tennessee probation and parole actually sent him to rehab.
They did, and according to Mr. Payne, they don't want him out of rehab, but he's gonna have to come up here and appear in court.
Okay, well, if he's indicted today, I'll issue a summons for him to be here. If he's not here next month, then I don't care if he's in a rehab or
Understand.
whatever.
This rehab that needs to be made before we can bring together.
Well, they're superior, they're above.
Superior at this point in time, like,
And this last session of the General Assembly, Commonwealth versus Anthony Richards.
He was picked up last night.
He's in jail, so I'll move him down to jail now.
Your Honor, can we go back to the Cody Smith case with Mr. Wittenberg?
Yes.
Mr. Gordon Anderson has confirmed he is in the rape trial in McCoy again today. So
We'll put it over to the May this
That's-
April the 11th.
yeah,
I know, but he's an attorney's not, they said his attorney's tied up in the race, so.
I don't even think he's here either.
He did issue arrest warrant.
He's not here. He was in, I was in the clerk's office this morning.
When he was told to be
He
here.
was instructed to be.
Okay, well, that's like that's sad.
And if he was here, I can go ahead and set it over to next month because of the attorney, but the fact he was told to be here and he didn't come makes it have a failure to appear, so I'm gonna issue.
But I just asked Ms. Harper to be recognized to be back here on May the 2nd, so she can testify.
She may go outside.
You need it.
So just tell her she needs to be back here. That's okay.
Okay. You need to she's here.
Issue a bench warrant for him for failure to appear. This one I just did. Shannon Smith. Shannon Smith. It's an expungement here.
I don't have any objection.
Okay. The order be submitted. Kaylie Swift. Kaylie or Kaylie? I don't know. What's the correct pronunciation of the first name?
Kaylie.
Kaylie, good.
Yeah.
Commonwealth versus Kaylie Smith, 24 CR 00170 R. Kaylie Smith. You're born in 2001, is that correct?
Yes.
Last four digits, social security number 2547.
Yes.
You're here today for the purpose of arraignment. Do you have an attorney?
Yes, it is Lee Wittenberg, but I'm unable to reach him, for his office or
Pardon?
his personal, so, Lee Wittenberg. So,
Wittenberg is here. Well, I'm gonna ask the public advocate to stand in for the purpose of arraignment. You have the right to remain silent. If you have any questions, you can step away from the podium and ask Mr. Page. The grand jury of Clinton County has returned an indictment charging him with lawful imprisonment of first degree, assault of fourth degree, and intimidating a participation. Intimidating a participant in the legal process. You understand those charges?
yes,
Just what they are, okay? You, Mr. Wittenberg, should be present for negotiation here at 9 a.m. in this courthouse on April the 26th, April the 26th. And your next court appearance is on May the 2nd, okay? Both of them are conditioned to your bond. And you said you're unable to get a hold of him.
Mhm.
When have you ever been in contact with him about this? Is he definitely representing you? Have you paid him?
Yes, I've just not reached him regarding that.
You what?
Today. I've just not reached him to come today, like I'm not able to get a hold of him. But yes, I have talked to him.
That's not a good sign for you. You see what I mean? He scheduled to be here today as a condition of your bond and you can't get a hold of him. You know, and you saw previously he wasn't here because he had a conflict as a trial date. So evidently he scheduled a trial date. On the regular rule day here, we got 1 day a month here and he's scheduling. So I would be a hold of him pretty quickly and be ready to have, because you're expected to be there. If you don't have him there, you have an attorney, okay? You want to give her copies of those indictments, letters, take it or go?
I gave you.
Already in there. Okay, well, you're expected to be with an attorney on April 26th, 9 a.m. here and here on May the 2nd, okay? Thank you very much. Kyle Thomas. Commonwealth versus Kyle Thomas, 23 CR 0051. Are you Kyle Thomas?
Yes, sir.
Okay. Were you born in 1996?
Yes, sir.
Last four digits, social security number 4517.
Yes, sir.
You're here today for a pre-trial conference.
Your Honor, I'm moving to dismiss without prejudice because I believe after reviewing all the facts in this case, the Commonwealth indicted the wrong person for a subsequent indictment.
What was the charge?
He was charged with wanton endangerment. I don't really want to go into the fact. but
Okay.
There was some
So
serious
you believe he's
issues.
wrongfully charged?
I do. I think he was
Do you have any
victim of a crime
objection?
rather than committing.
Do you have any objections being dismissed?
No, sir.
Well, that's the correct
Very-
answer,
very
right?
happy.
I would like to get it without prejudice, till I can get his cooperation in this case, then I'll dismiss the
Okay,
witness.
dismiss without prejudice, which means the Commonwealth wants you to cooperate, and they will, they'll dismiss it and switch it over to prejudice, probably, okay?
Thank you.
John Tucker.
Thank you, Your Honor.
Yeah. John Tucker. For sentencing. Mr. Cross, you're listed.
Oh. He should be in, he's in jail, and yes, yeah, should be in the custody down.
Your Honor, he's here in the Clayton County Jail.
Okay, we'll get him in when we come down there, okay? Candace Tweety. Candace Tweety.
Thing I knew about that.
Commonwealth versus. Are you okay, Miss Tweety?
Yeah, I've got some allergies going on.
If I thought I set them on, but
We have a capacity to drug test someone. We got somebody who do a drug test. Mr. Cross, would you move over? You have somebody to do a drug.
I've got stuff if somebody can.
Okay, we need a female. You just have a seat over there. Gonna do it. You don't look right to me. Angela Wallace. Commonwealth versus Angela Wallace. Are you Angela Wallace?
yes.
Were you born in 1972?
Yes,
Last four digits of social security number 7871.
yes, sir.
Is that correct?
Yes, sir.
Okay, this is 24 CR 005. You're representative of Mr. Cross. You're here for a pretrial conference and a motion to withdraw.
Your Honor, based on a conversation with the Commonwealth, I developed what I perceive as a conflict, and I think she'll qualify for DPA.
Yeah, what public advocacy?
Judge, I need to have Mr. Wallace, if she's, you got an affidavit, I'm gonna put that on the record.
What is it?
I had her complete an affidavit.
Okay. Okay, I'll appoint her. Now, where, guess we need to do a negotiation day on April the 26th.
Yes,
And
Judge.
the next court appearance, May the 2nd. William Willis.
She's done.
Commonwealth versus William, are you William Willis?
Yes, Your
You
Honor.
were born in 1997.
Yes, sir.
Last four digits, social security number 1336.
Yes, sir.
Here for the purpose of arraignment. Do you have an attorney?
Behind him, Judge.
Okay. Okay, you got that.
Willis, William Willis. The judge has a point of order, I think well, no, he has two cases.
That's right. Twenty-four CR 0014 and 24 CR 0015. Mr. Willis, you have the right to remain silent, okay? I'm gonna read the charges and the indictment. Given to your attorney, if you have any questions, you can step away from this podium. The grand jury of Clinton County is charging you with possession of controlled substance in the first degree. In possession of controlled substance not in the original intent, that is in 0015. And in 0014, the grand jury is in charge you with unlawful imprisonment in the first degree and receipt of a card in violation of KRS 434-570 to 434-610. which involved a credit or debit card. You understand what those charges are?
Yes, Your Honor.
Counsel, you acknowledge the identity of Mr. Willis, receipt indictment, waive formal reading and arraignment, enter plea of not guilty or so help you.
Yes, Your Honor.
Mr. Willis, you should be here on April 26th for negotiations. You'll be back here on May 2nd for your next court date. Both of those are conditions of your bond. You understand that?
Yes, Your Honor.
Sign reciprocal discovery orders in both cases, which means the Commonwealth is giving you information concerning your case to help prepare your defense. Okay, great.
Thank you, Judge.
Thank you.
Cameron Wright. She okay?
Yeah, good on all.
Okay. Commonwealth versus Cameron Wright. 24 CR 0021. Are you Cameron Wright?
Yes, Your Honor.
You were born in 2002.
Yes, Your Honor.
Last four digits, social security number 4725.
Yes, Your Honor.
Here for the purpose of arraignment, you're represented by counsel, you have the right to remain silent. The grand jury of Clinton County has charged you with operating motor vehicle under the influence, aggravating circumstance, first offense, and wanton endangerment of first degree. Do you understand those charges?
Your Honor.
Counsel, you acknowledge the identity of your client, received indictment, waive formal reading or arraignment, not guilty, reserving all pretrial motions.
Yes, Your Honor.
Sign a reciprocal discovery order here. Commonwealth will be under, giving your attorney get information to help prepare for defense under obligation to continue to do so. You'll be back here on April 26th for negotiation day and May 2nd. For your next trial date, both of those are here at 9 a.m. in our condition of your bond, okay?
Yes, Your Honor.
Okay, let's go back to Candace Tweety. Commonwealth versus Candace Tweety, 23 CR 0058. You are Kansas Tweety.
Yes.
You were born in 1997.
Yes.
Last four digits, social security number 2464.
Yes.
You're here for a pretrial conference.
Also, Judge, we defendants filed a motion to suppress evidence also in this case. So we're ready.
Okay, what is it, warrantless search?
Yes.
We got running a little bit ahead of schedule on them. We don't have anything scheduled till 10, so we got.
I have an officer here.
Okay, let's bring the officer. Ready to go.
Yes, Judge.
Do what?
Yes.
Yeah. You want to make some room for them there?
Absolutely.
Officer, you gotta take a stand over here. You raise your right hand, you swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
Yes.
You may proceed, Mr.
Please state your name for the record
Parker Hickman,
and what's your occupation or profession, Mr. Hickman?
police officer, Albany Police Department.
And were you so occupied on October 30th of 2023?
Yes,
On that occasion, did you have, on that date, did you have the occasion to have an interaction with Miss Tweety?
yes.
Tell the court when you first observed Miss Tweety that night and who she was with and what she was doing.
I encountered a vehicle at next to Somerset Oil being operated by John Brown. I knew that Miss Tweety and Brown were supposed to be a couple.
All right, was she in that vehicle?
Yes, she was a passenger.
What kind of vehicle was it?
It was a 2007 Dodge Ram pickup.
Is it a two-door or a four-door pickup?
It was a
And what brought your attention to Miss Tweety?
I knew there was an active warrant for her arrest.
You recognized Miss Tweety in the car?
Yes, as passenger.
And you knew, you had personal knowledge that there was an active warrant for her arrest?
Yes.
What did you then do?
I followed the vehicle. We came into town. We come to the stoplight at the intersection of 1590 and 127 business route. Mr. Brown turned right and then failed to give a turn signal. I then made a traffic stop at Collins Dairy Tree.
All right, at that point, once the vehicle was stopped, did you confirm that it was the person that you thought it was, Miss Tweety?
Yes, I confirmed that through
And did you
dispatch.
confirm by dispatch that there was in fact an active warrant against her?
Yes.
What did you then do in relation to the warrant?
I placed Miss Tweety under arrest.
And after you arrested her, did you initiate a search of Miss Tweety and the area immediately around her?
Myself, no. Once I done the traffic stop, I was running all the information on Miss Tweety and Mr. Brown and the vehicle. Sheriff Markham and one of his deputies showed up on scene. And they kind of took over the
All
investigation.
right, what did the sheriff do then?
I was dealing with Miss Tweety. They were talking to Mr. Brown. At one time, I noticed the deputy had Mr. Brown out in handcuffs. He had been informed by dispatch that there was an active warrant on Mr. Brown, but that come out.
That wasn't accurate, was it?
There was not, no.
Go ahead. What did the sheriff then do?
At some point, he had contacted K-9 from Wayne County.
And what did the dog then come?
Yeah, the dog did come, yes.
And then what happened?
The dog hit on the vehicle and then a search was made.
All right. Prior to the dog being there, had you placed her under arrest?
Yes.
Judge, this is a case, clearly, this is a Gates versus Arizona case. When she was arrested.
Well, you can argue in a few minutes. He gets a chance to cross.
All right.
I know it'd make things quicker.
Yeah, I just want to read it.
So you're mindful of my time.
Time to take it, Judge. I think.
Well, would you like to come up and inquire?
Yes. Officer Hickman, can you explain it again, the reason for the traffic stop in particular, why you initiated blue lights and would have
Well, I
the car over?
observed Miss Tweety. I was 99% sure Miss Tweety, that was her in the passenger seat of the vehicle.
Okay.
Of course, I was looking for that vehicle, knew she would be in it with Mr. Brown. When we got to the stoplight, he failed to give a signal, so that was my PC. Really didn't need probable cause because I'd seen her in the vehicle.
So your testimony is that you were already on the search of that particular vehicle?
Well, no, I was out patrolling and come across it.
But you're saying that you had prior knowledge or that you had been told to investigate or to try to find that vehicle in particular?
Well, I mean, I was made aware of that, I check e-warrants daily when I work, and I'd seen that there was active warrant on Miss Tweety.
So did you have prior knowledge about any kind of association with Mr. Brown and Miss Tweety?
I mean, I knew they were a couple.
Okay. Now, have you ever had the occasion of confronting or encountering Miss Tweety in any of course of your duties as a police officer?
I don't know if I've ever dealt with her prior to that or not.
Okay. So your basis of knowledge regarding her identity and who she was, could you explain to the court how you knew her?
Well, I mean, I just associated her with Mr. Brown.
So you've never had any encounter with her in the past?
I don't think
Correct.
so.
And you had never arrested her or investigated her in the past, correct?
Not at that time, no.
You had not been told about her being in the vehicle with Mr. Brown by some other officer or by anybody else?
Well, they told me that they were a couple, and if I seen the vehicle, that she would probably be in there. And then when I met it, I seen the female hunkered down in the vehicle.
Okay. But again, you wouldn't know her from any other
At
woman?
that time, no.
Okay. So once you initiated the traffic stop, and was there some reason why you actually did flip the blue lights on and pull
Yes,
the
he
vehicle
failed to
over?
give a turn signal.
Failed to give a turn signal. Now, where were they in what location? Because the narrative that I've received doesn't really describe any kind
Is
of
at the
location.
intersection of 1590 and 127 Business Route.
Okay, and which direction was Mr. Brown?
They were traveling south and then they made a right turn, which would have been west.
Okay, and so pulling in there to Collins Dairy Treat?
But they turned west on 1590 and then Collins Dairy Treat's just a little piece down on the left.
Okay, and so once you initiate the traffic stop, do you have any encounter with Miss Tweety herself? Do you ask her any questions or do you confront
I
her in any way?
got Mr. Brown's information and got her information. Ran the tag on the vehicle and ran both of them.
Okay.
OL checks on them and check for E-warrants.
Okay, and so you checked again for E-warrants?
We always confirm, yes.
Okay, and then once you confirmed, did you actually initiate an arrest of Miss Tweety?
Yes.
Okay, and so at the time of her arrest, was she placed in your cruiser?
Yes.
Okay, and so she had no control or had any, she wasn't in immediate control of any of the vehicle? She wasn't around the vehicle at the time?
I got her out of the vehicle.
Okay. So who initiated the call to the K-9 unit?
The sheriff.
The sheriff, our
Yes.
sheriff, here in
Yes.
Clinton County?
Yes.
Okay, and so after that call or request was made to the K-9 unit, and again, where is the K-9 unit?
Wayne County.
Wayne County. How long can you estimate or approximate for the court, the time it took from the call to the Wayne County Sheriff's Department, I presume, for the K-9 unit to actually?
I have no idea. I was dealing with Miss Tweety. I don't know exactly when he called him.
Okay. Had she already been taken away from the scene?
No, she's still on scene.
Okay, still on the scene. So there's no general approximation of how long it took for
No, I can't say.
more than 10 minutes, less than 10 minutes?
Because he's answered that question 3 or 4 times.
Judge, she is just in the best position to give us a testimony.
Well, I made the traffic stop at 1447 and placed her on arrest at 1501. So I don't know if the K-9 was called prior to me placing her on arrest. I don't think it was. I don't know.
Was there any reason to keep her there on the scene while the K-9 unit was en route?
I was doing the process and her warrant and talking with Mr. Brown. Sheriff and them still there with Mr. Brown.
And as far as her warrant was concerned, was she ever detained or was she ever formally arrested and incarcerated based on that warrant? Was she ever detained or was she actually formally incarcerated based on that warrant?
Yes, she was. She went to jail on that warrant.
Okay. I guess at what time did you leave the scene?
That I do not know.
Okay. Did you help and aid in any of the search of the vehicle at all?
I was in and out with it. I was watching her and then it was a single cab vehicle and you got 3 people. You can't very well get 3 people in the vehicle to search.
Okay, so you yourself didn't really have any
I
hands-on
didn't
searching
hands-on,
of the vehicle? Okay. I believe that's all the questions I have.
You have any redirect?
Just briefly, where were the items that were taken into custody found?
Although it's scattered into some of her personal stuff, bags, the
Judge, I would object. He just answered he had no hands-on experience with regard to the search.
Observed it, I think.
Asked him if he
You
observed.
observed the search.
yes. Parts of it.
Where were the items found?
I'd say some of them was in her personal stuff. The vehicle, I mean, it was just scattered all amongst the vehicle, along in some of her personal stuff.
And this was a 2-door pickup truck.
Yes.
She would have had access and would have been able to reach any part of that interior of that vehicle.
What was found? Nobody's ever testified what was found. What was found?
There's a little bit of marijuana, possible meth, but for some reason it didn't get checked at the lab.
Would you? Please examine the documents that I have in my hand, not for them, tell the court where the different items were located and what you found.
I'm not gonna be able to say exactly where we're at in the vehicle.
Judge, I was objecting
Wait just a second.
if he is to testify regarding.
Wait just a second. Okay, Mr. Hunley, will you come back over here? Now, you want to come up here
Yes.
so I can hear you if you
Yes.
get that objection?
The objection regarding any items that he's going to be testifying to, I believe there needs to be someone who wrote that document. I don't think Mr. Officer Hickman's testimony
Let
is
him
that
look
he
at
was.
look at the document. If he can tell us, he can tell us, and if he can't, he can't.
Proceed.
You know, I can't tell you exactly where these items are located.
Were the items located in the interior of the
Yes.
two-door truck?
Okay, now read off is that a citation somebody else wrote?
No, it's a KSP 41 form that was sent to the
Submitted
lab.
for a test?
Yes.
What does it say was submitted?
Got one plastic cylinder with, residue inside, one plastic bag containing crystal substance, one green plant, one white pill, identified as M365, one bag with white powder and pill enclosed.
And all those were found as incident to the arrest of Mr. Tweety.
Correct.
Okay. And you have any backup questions?
I had nothing further.
You have anything?
I have nothing further.
You have any other witness? This witness be excused?
Yes.
You may be excused. Thanks, sir. You have any further witnesses?
No, Your Honor.
Would you like to call any witnesses?
No, Judge, but I would like an opportunity to brief this issue and
Okay.
give you a written explanation.
What are we scheduled in this case? Is there a negotiation day scheduled?
I'm not aware of it, Judge.
Is there a negotiation day scheduled?
Not currently, Judge. Today was for pretrial conference and we didn't file a motion, so
Okay,
no.
well, why don't you schedule it for a negotiation day on the 26th? And both of you have, you file maybe 5 days before that or something like that. And give the Commonwealth a time to respond. And then y'all can negotiate once they see what your argument is to see, and then y'all can be back here for a ruling on May the 2nd, okay?
In all due respect, Your Honor, I think this is a case that doesn't require intensive briefing.
Well, then you can not brief it then. We'll just let him brief it.
Okay, Judge? Yeah, certainly. 26 and for negotiation conference, May 2nd for pretrial conference,
Negotiation is April the 26th in your next court appearance here,
May 2nd.
both of them at 9 a.m.
Okay, thank you, Judge.
I would suggest you be at the negotiation day with your client.
Sir?
Yeah,
Thank you, Your Honor.
yeah. Is that it? Timothy Peran. Commonwealth versus Timothy Peran, 23 CR 0064. Are you Timothy Peran?
Yes, sir.
Born in 1970.
Yes, sir.
Last 4 digits, social security number 7334.
Yeah, yes, sir.
Okay, go ahead.
Your Honor, Mr. Cross filed a motion to suppress, and I filed a motion to continue to May the 2nd. We have 2 witnesses, Brandon Poole and Jordan Tucker, and Mr. Tucker's from Louisiana this week. So I'm asking if we can hear the motion on May 2nd.
May 2nd it shall be.
Okay.
Okay. Now, we have nobody else in the courtroom here, so we'll go to Roder.
I think we got Mr. Stevens, John Stevens. You know, about that.
I don't have him on here. Commonwealth versus John Stevens. 21 CR 0076. Are you John Stevens?
Yes, sir.
Yeah. What's it all? You have an attorney? You have an attorney?
He was, I don't know if he still is or.
Yeah, I mean.
What do you got, Mr. Stockton? What's your year of birth, Mr. Stevens?
1977,
Last four digits, your social security number?
3940.
Okay. This is a motion for revocation of a pretrial diversion, is that right?
Yes, Your Honor.
What is-
We've been in court numerous times, and since we've been in court the last time, Mr. Stevens has made payments on this. And he's down to $902.20, but he owes a little over 1,000 counting the restitution fee. But he's not made any payments since the 1st of March. And according to Mr. Payne, he had a positive test for benzodiazepines on March 19th. I can put him on to testify, so I can see where he's
What's
money.
the original charge?
It was theft. Basically, him and his wife was working out the Royal Inn, and they were using the motel credit card and absconding with funds. It's originally about $5,000 or $6,000. Mr. Stevens agreed to pay it. He was going to pay it off, and I dismissed the case against her. And we've been now, the plea was entered. Which I'll have to look.
10, 12, and 19.
10, 12 of 19. Here we are in the year 2024, and it's not paid out.
Mr. Stevens, you have this paid off in full, or be back here on May 2nd with your toothbrush. Okay. You understand what I'm saying?
Yes, sir.
Okay.
We enter an order to that effect that he's got to May the 2nd. Pay
Yeah,
everybody.
don't come here and turn yourself in. Now, and on that day, we're gonna talk about between now and then, if you pay this off, I'll give you a pass on this one dirty drug test that you got. But you come ready that day or anytime between now and then, that probation and parole wants to test you.
Yes, sir.
And you need to you need to tell him today, if he tests you, whether or not you be dirty or not. You just need to tell him, I'm not gonna ask you to do it on the record.
Right.
You know, but if you're dirty, you need to go ahead and tell him, and he give you some time to clean up between now and then. You understand? I'm trying not to send you to penitentiary.
I appreciate it, sir.
Okay, you have that paid off and be back here, okay?
Thank you.
Okay, let's go to Roder. Please. Roder, if you'll turn your camera on. Commonwealth versus Daren Riddle. This is 23 CR 0062 and 23 CR 0068. You're Daren Riddle.
Yes, sir.
Born in 1972, is that correct?
Yes.
The last four digits of social security number are 4086.
Yes.
You're here today on a pretrial conference. Mr. Stockton, will you come forward?
Yeah, Ms. Anderson, will do the plea.
Yeah,
You got a plea here. Is it a felony plea or?
it's a felony plea.
Mr. Riddle, a motion's been tendered that says you wish to enter a plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given?
Yes.
Are you the same person named in indictments number 23 CR 0062 and 23 CR 0068?
Yes.
Is your judgment impaired today in any way?
No.
Have you discussed this matter with your attorney, and are you satisfied with his advice?
Yes.
Have you reviewed the evidence Commonwealth has against you, believe you're fully informed about your case?
Yes.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and the United States Constitution. Before I can accept a plea, I need to know that you understand those rights. I'm going to go down through the rights. At the end, I'm going to ask you if you understand them. You have a right not to testify against yourself. No one can make you say anything. You have a right to speedy trial by jury, right to be represented by counsel at your jury trial. right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses to your favor, the right to appeal this matter to a higher court if you lose, the right to part of the Commonwealth and prove beyond a reasonable doubt that you're guilty of charges against you.
Yes,
You understand that by entering a guilty plea today, you give up all those rights. You understand that?
yes,
Now, may consider the Commonwealth's recommendation by that may apply in range of sentence provided below. I don't have to accept the recommendation. Prior to accepting the recommendation, I will wait the pre-sentence investigation for probation and parole. Now, he's a state prisoner now. Is he eligible to waive the probation and parole report?
Let me look in that and I'll let you know by the time we get to the end.
In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea and proceed to trial. Now, what is the Commonwealth's recommendation?
Yes, Your Honor. Upon a plea of guilty to indictment number 23 CR 68 for the charge of theft by unlawful taking or disposition over $1,000, the defendant shall receive a sentence of 2 years. Upon a plea of guilty to indictment number 23 CR 62 for the charge of receiving stolen property, the defendant shall receive a sentence of 7.5 years. The 2-year sentence and the 7.5 year sentence shall run concurrently for a total of 7.5 years to serve. The 7.5 year sentence shall run consecutively to Russell indictment number 15 CR 25. The Commonwealth recommends the Department of Corrections place the defendant in a facility that has the SAP program. Thus, the defendant shall enter and complete the SAP program. The Commonwealth opposes probation, shock probation, shall receive credit for time served, shall pay court costs at the discretion of the court, and the defendant agrees to have any and all evidence in the above style cases disposed of in accordance with the laws of the Commonwealth of Kentucky and the holding agency.
Mr. Riddle, is that your understanding?
yes,
Are you pleading guilty because you did commit the acts charged in the indictment?
yes,
Are you doing so of your own free will?
yes,
Knowing your constitutional rights, I've explained it to you, still your desire to enter this plea and allow the court to fix your punishment under law. You understand that after entering this plea, future convictions could be enhanced as far as your range of penalty.
yes,
Is that your signature on the motion?
yes,
You can hold it up there so you can see it. See that? It's your signature.
yes.
I'll accept the plea. Now, is PSI necessary?
They was one done in November.
So
in
it
your
is,
court,
I'll
yes.
order pre-sentence investigation report to be done by probation and parole and schedule your sentencing for May the
Judge,
second.
it can be passed. It can be passed.
You did one in Cumberland.
He done one in Cumberland in
You
November,
did one in
Yes.
Cumberland,
in November.
so I didn't understand.
Yes, I'm sorry.
Okay, well, I won't have to bring you back here for sentencing, and we can just go ahead and sentence you and sign the judgment. Isn't that right, counsel? You have
Yes,
no
Judge.
objection to that?
Hey, Your Honor.
Good luck to you.
Hey, David. Hey, Your Honor.
Do what?
I got 191 days credit. Can I get that credit too?
Well, they'll work through that administratively. I don't know. They'll be in contact with your lawyer. If you don't agree with the number of days credit, you need to tell your lawyer. He'll get a hold of, there's a process to it.
Yes, and you do not receive double credit. He's receiving that credit in another case. So.
Okay, they'll be in contact.
All right, thank you.
I'm gonna waive the court costs. I'm not gonna charge you court costs because you're gonna be incarcerated, okay?
Thank you, Judge.
Okay, thank you. Roder, that you're excused. Thank you for your cooperation. Let's go to the Dare County Detention Center. The Dare County, are you on the line? Okay, there's Dare County. The camera is on, Dare County. You need to turn the mic on. Dare County, your computer is locked. Somebody call the Dare County Jail and tell them their computer's locked and turn it off and on. Let's go. Russell County, are you on the line?
Yes, sir.
Russell County? Russell County.
Yes, sir. Can you hear me?
Okay, let's go to Wayne County. Russell County, you're on there now. Okay, Russell County. Commonwealth versus Luther Connor. Are you Luther Connor?
Yes.
This is 22 CR 0001. Mr. Connor, were you born in 1977?
Yes.
Last four digits, social security number 5220.
Yes.
Okay, what do you have, Mr. Stockton? Come up.
Your Honor, this is a possession case, 3 years. He's on pretrial diversion. He absconded October of 2nd, 23, and he was picked up April the 1st, 24, so about 9 months, seven months.
You know, stipulate to that.
Mr. Connor, you want to stipulate to the revocation?
I didn't hear you. I didn't hear what you said.
He asked you if you want to stipulate, you agreed that you absconded?
Oh, yeah, I absconded.
Okay, well, I will revoke the pretrial diversion, order pre-sentence investigation report to be done by probation and parole. And you appear back for sentencing on May the 2nd, okay? They'll be over to interview you, Mr. Collins. Kevin Hadex. Commonwealth Kentucky versus Kevin Hadex, 15 CR 00101. Mr. Hadex, were you born in 1966?
Yes, sir.
Last four digits, social security number 3194.
Yes,
We're on a 202A petition.
Yes, Your Honor, we received a report back from KCPC. He's not competent or criminally responsible according to their report, so I filed a 202A petition and asked the court to proceed with that and be held until that's taken care of. And then I've got a proposed order I sent in declaring him not responsible or competent to stand trial.
And you want to schedule a hearing on May the 2nd?
Yes, will he need a guardian ad litem appointed? I think so, so we can have a.
Yeah. Give that McCoy.
Who's next on the list? Yes. Boy, Holly, Perry.
Even they said he get one phone.
Just to go,
You
she,
did the other one, so she will be familiar with.
that's why I said, she was his guardian ad litem and coming, and she's familiar with the
Did a
case.
good job.
Yeah. Okay. Mr. Haddix, they'll be up to see you, okay? Try to help you out, son.
All right, appreciate you, Mr. Armstrong Williams.
Okay. Savannah Jackson.
She'll be right here, Judge.
Okay, Barry Rose. For sentencing. Commonwealth versus Barry Rose. 24 CI 0011 and 24 CI 003. Are you Barry Rose?
Yes, sir.
What is your year of birth, Mr. Rose?
1978,
And the last four digits of your social security number?
8692.
Okay, you're here for sentencing. Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole?
Yes, sir.
Is it substantially correct?
Yes, sir.
Mr. Cross, is there any reason that this gentleman should not be sentenced?
No, Your Honor, I believe it's timely and appropriate.
On a plea of guilty and on indictment 24 CI 0030 for the charge of possession of controlled substance, defendant shall receive a sentence of 2.5 years. On a plea of guilty to information indictment. And what indictment number was assigned on information indictments? 11.
Yes.
24 CR 00011. For the charge of possession of controlled substance first degree methamphetamine, defendant shall receive a sentence of 2.5 years on plea of guilty. Information indictment 24 CI 0011 also include different information. No. Okay. For the charge of operating motor vehicle, alcohol content 08 under the influence, first offense, he shall pursue a fine of $200 for cost upon plea of guilty of information over 24 CI 0011 for the charge of failure to maintain insurance. He will receive a fine of $1,000. The 2.5 years in indictment 003 and the 2.5 years in information 0011 shall run consecutively a total of 5 years, serve 137 days in jail with a balance of probate, 5 years supervised. He shall receive credit for time served. Now, sir, I want to ask you, since this was done by information, you understand that these two felony charges, one in the indictment, one in information, could enhance any sentence you have if you have felonies in the future. Do you understand that? Right?
Yes, sir.
Okay, and you also understand on your DUI that if you get another DUI in the future, it could be enhanced because of your entry of appearance on this. You understand that?
Yes, sir, I do.
Okay. Now, what's the total court cost?
The total, everything comes off was $1,960.
Okay, $1,960 is your total amount. I'm gonna allow you to pay that at $60 a month. Okay,
Yes, sir.
first payment will be due 30 days after you get out.
Your Honor, it's our computation that I believe he's got. I'm sorry.
I'm just gonna give him a time to report.
Okay, go ahead.
I believe his time is
Stockton, Mr. Pennington, don't distract Mr. Stockton. You go.
easily distractible. I believe Barry's got his time in today. And so if we could get a order releasing him as soon as possible, Megan, that would be great. If you could do
Well,
that.
what's the probation policy?
It said 137 days, and as of today, I think he will serve 141. So.
What's what we're supposed to say?
Mr. Rose,
Yes, yes.
when you're released, I need you to be at Monticello Probation and Parole this coming Tuesday, the 16th at 9 a.m. your time.
That's Central Time?
Yes,
Yes, sir. Okay,
this
Tuesday.
coming Tuesday, the 16th at 9 a.m. And if you fail to report, I'll have to get a warrant, okay?
Yes, sir, I'll be there.
Barry, I'll tell your mother, but when you get home, call me.
Okay, thank you.
Thank y'all.
Thank you, Your Honor.
Anthony Shaw. Commonwealth versus Anthony Shaw, 24 CI 006. Are you Anthony Shaw?
Yes, sir.
Born in 1990.
Yes, sir.
Last 4 digits, social security number 3671.
Yes, sir.
Okay, you're here today for sentencing. Your attorney's here. Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole?
Yes, sir.
Is it substantially correct?
Yes, sir.
Is there any reason, counselor, that this gentleman should not be sentenced?
No, Your Honor.
Upon plea of guilty to possession of controlled substance, first degree and methamphetamine, he shall receive sentence of 1 year to serve. The 1 year shall run consecutively to Wayne Circuit Court Indictment 22 CR 00174-001. And the court cost $155 can be paid at $30 a month, starting with 30 days after your release. Okay?
Thank you,
Yeah.
Judge.
Thank you.
Good luck, Anthony.
Thank you.
We're ready for Savannah Jackson. Savannah Jackson. Commonwealth of Kentucky versus Savannah Jackson. Are you Savannah Jackson?
Yes, sir.
Were you born in 1998?
Yes, sir.
Last four digits, social security number 2524.
Yes, sir.
You're here for a pre-trial conference.
What is it?
Yes, Your Honor, we have a plea and it's a diversion.
Ms. Jackson, I understand a motion has been tendered that says you wish to enter a plea today. Is that correct?
Yes, sir.
You're currently under the influence of drugs or alcohol.
No, sir.
This plea freely and voluntarily given.
What is it?
All right, is this plea freely and
Yes,
voluntarily
sir.
given?
Yes, sir. Sorry. Sorry.
Are you the same person named in the indictment that I identified just a second ago?
Yes, sir.
Is your judgment impaired today in any way?
No, sir.
Have you discussed this matter with your attorney and are you satisfied with his advice?
Yes, sir.
Have you reviewed the evidence the Commonwealth has against you and you believe you're fully informed about your case?
Yes, sir.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and the United States Constitution.
Yes,
I'm
sir.
going to read through those rights with you to make sure that you understand them. If anytime you don't understand them, you just raise your hand.
Okay, sir.
You have a right not to testify against yourself. No one can make you say anything. Your right to speak, trial by jury, your right to be represented by counsel to jury trial. The right to confront and cross-examine all witnesses called to testify against you. The right to give evidence. The right to call witnesses in your favor. The right to appeal this matter to higher court if you lose. The right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges against you. Understand that by entering a guilty plea today, you give up those rights. You understand that?
Yes, sir.
Yeah, I may consider the Commonwealth's recommendation, but I may apply to a sentence that's allowed by law. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have a right to withdraw your plea and go to trial. Do you understand that?
Yes, sir.
Have you previously been diverted in the last 5 years?
No, sir.
Have any felony convictions in the last 10 years, or are you on probation?
No, sir.
You understand if you fully complete the diversion program, the charges will be dismissed pre-trial diverted. You understand if you successfully complete the program, the charges
sir.
will be dismissed and you can get your record expunged. You
Yes,
understand?
sir. Yes,
You
sir.
understand if you don't complete the diversion, if you're brought successfully, you'll be brought back before the court and a scheduling sentence will be held and you would be a convicted felon.
Yes, sir.
Now listen very carefully to what the Commonwealth has to say. You need to speak up.
Yes, Your Honor. Upon a plea of guilty to possession of a controlled substance, first degree methamphetamine, the defendant shall receive a sentence of 3 years. Upon a plea of guilty to wanton endangerment, first degree, the defendant shall receive a sentence of 5 years. The two sentences shall run concurrently for a total of 5 years. Serve 100 days in jail with the balance pretrial diverted for 5 years supervised. Any contact with the victim shall be in accordance with the orders of the Clinton District Court. The defendant shall enter and complete the Clinton Specialty Court Program. The defendant shall receive credit for time served and be released from incarceration the morning of drug court orientation. The defendant shall obtain gainful employment or do a minimum of 30 hours of community service until gainful employment is obtained. The defendant agrees to have any and all evidence in the above style case disposed of in a manner that is consistent with the laws of the Commonwealth and the holding agency.
Ma'am, is that what you agreed to?
Yes, sir.
Are you entering this plea because you did commit the acts charged in the indictment as amended?
Yes, sir.
Okay, you understand you're doing this of your own free will, is that correct?
Yes, sir. Yes, sir.
Okay, knowing your constitutional rights have explained to us is still your desire to give up those rights, enter a plea of guilty, allow the court to fix your punishment.
Yes, sir.
And I'm gonna ask that the document be brought up here. Is that your signature on there, ma'am?
Yes, sir.
Okay. Okay, I'm gonna accept you. When, has she been voted on in drug court yet?
I don't think she's been voted on yet. She's,
Oh, you what?
Got the order return and everything. It's in there.
Okay. Have they voted on it yet?
not voted yet. No.
Okay, well, the drug court will vote on you and they'll schedule you an orientation, and as soon as the orientation comes, I'll let you out, okay?
Yes, sir. Thank you.
Okay, good luck to you.
Thank you.
We have anybody over there else with you, Russell County?
No, sir.
Okay, thank y'all very much. You're gonna be excused.
Thank you.
Let's go to Wayne County now. Is Wayne County back on there? Okay, let's go to Dare County, try Dare.
Judge, I think Wayne County's, I see Mr. Brown.
Yeah, there's Wayne County. Let's go to Wayne County. Commonwealth versus John Brown, Wayne County. Are you John Brown? The microphone needs to be turned on at the jail, at the Wayne County Jail. Your microphone is turned on.
Can you hear me?
Yeah, that's got it. It's a bond forfeiture on Mr. John Brown.
Yeah, my understanding is gonna stipulate he didn't, keep up with Mr. Bookout's device and keep it charged. Time he was on home incarceration, Mr. Bookout did get his device back. But I'm asking these bond be revoked from the Wayne County and set him for a negotiation day and another pretrial.
Okay, you didn't keep up with your device as you were supposed to, but it has been returned. You're to be present on April the 26th at 9 a.m. for negotiations, and your next court date is May the 2nd. Your attorney will be over to see you.
Okay. All right. Thank you.
Judge, I guess the only other thing, and I just discussed this with Mr. Stockton, with regards to the charges, and we may be able to wrap this up in plea, but I think that's what Mr. Brown was ready to address. The labs came back and, instead of it being a possession of fentanyl, the labs come back as methamphetamine.
What the world's come to, it's a lot better to have meth than fentanyl. Sure.
Well, you don't need to deal with that negotiation.
Yes, Judge, I think that's what Mr. Brown was standing up for. So, John, we talked about that. Thank you.
Okay. All right. Thank you.
Rebecca Major.
Yes, Judge.
Are you Rebecca Major?
Yes, sir, I am.
It's 21 CR 0066. And you born in 1994?
Yes.
Last four digits of social security number 1335.
Yes.
You're here on a shock probation revocation. What's going to have to offer?
The allegations are she was positive for meth and heroin on or about March the 15th. She was offered treatment, and I think, to paraphrase, she said she'd just go on to jail. That's was rather than go to treatment. It's a little more elaborate than that. They can testify if he needs to.
And Judge, if I may, first, and we may save a little bit of time, Ms. Major is being incarcerated there in Wayne County, has now decided that she would like the opportunity to go to treatment. She is in the the assessment stage at Sky Hope, pending a decision from the court. I know probation and parole.
She stipulate shock probation.
Judge, she was hoping to go to rehab today.
I would think that I would want to let it go through probation parole. If she wants to be assessed again, let them decide where she needs to go.
Okay, I'm going to revoke the shock probation and have her assessed. Recommend that they send her to a treatment place as soon as they can.
If you revoke her though, she becomes a state.
Is that what you want her to do?
That's what was requested.
I filed a motion to revoke because she said she didn't want to be treated. That was.
Now she says she does want to go.
Yeah, so either she's going to either be assessed for treatment or she's going to be
Well,
revoked.
which one will you accept? I mean, she.
I'll accept the treatment through probation program.
Absolutely.
We'll assess you for treatment, won't revoke you immediately, okay?
Okay.
You're gonna have to get with it here and help yourself. I know things are not going well for you.
Yeah.
But there's a brighter day here. You can avoid the penitentiary and go through treatment and get your life back on track, okay? So
Thank you, Judge.
I hope you do that, okay?
I will.
If you don't do that, you know, what almost happened to you today can happen, okay?
Yeah. Okay, thank you so much.
County, thank y'all very much for your cooperation. I don't think we have anybody else with you. Y'all can be excused. Thank you.
Thank you.
Okay, now. Adair County,
There we go.
there we go, Adair County.
Yes, sir.
Commonwealth of Kentucky versus David Brinker. This is a Cumberland Circuit Court case.
Yes, sir.
Are you David Brinker?
Yes, sir.
Okay. Were you born in 1965?
Yes, sir.
The last four digits, social security number 2619.
Yes, sir.
You're here for sentencing today. Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole?
Yes, sir.
Is it substantially correct?
Yes, sir.
Counselor, is there any reason this gentleman should not be sentenced today?
No, Your Honor.
On a plea of guilty to possession of controlled substance, first degree, defendant shall receive a sentence of 3 years, serve 30 days, balance probate for 5 years. The defendant agrees to pay restitution costs in the amount of $434 to the Cumberland County Fiscal Court to be paid in full within 30 days of sentencing. She shall obtain gainful employment. What are the court costs in this case? $215, and I'll let you have 90 days to pay that in full too. So the total is $649. You shall have paid within 90 days, okay?
Yes, sir.
Okay.
Mr. Brinker, when you're released, you need to contact the Dare County Probation and Parole as soon as you're released, okay?
And Judge, let me
Yes, sir.
today,
I'm gonna release you today. But
Thank you,
before I
sir.
release you, you guys should have the jail to help you call over to the probation and parole office to see if you can come over and see them today. If you can't see them today, you definitely need to talk to them and they'll set the date for you to come in, okay?
Yes, sir.
David, is like I talked about yesterday. Good luck.
Thank you.
Stephen Bruce. Stephen Bruce. Cumberland Circuit Court, case number 24CR006. Are you Stephen Bruce?
Yes, sir.
You're here today on a pretrial conference. Were you born in 1985, Mr. Bruce?
Yes, sir.
Last four digits of your social security number is 0456.
Yes, sir.
You're on a pretrial conference. What do you have?
Can I be sentenced today?
Mr. Bruce, I've been informed that you wish to enter a guilty plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person we identified just a minute or two ago as being involved in 24CR006?
Yes, sir.
Have you discussed this matter with your attorney?
Yes, sir.
Is your judgment impaired today?
No, sir.
Are you satisfied with your attorney's advice?
Absolutely.
Okay, have you reviewed the evidence the Commonwealth has against you and you feel like you're fully informed about your case? You have
Yes,
certain
sir.
rights you have certain rights under the Kentucky United States Constitution. Before I accept the plea, I need to know that you understand those rights. You have a right
Yes,
not
sir.
to testify against yourself. No one can make you say anything. A right to speak trial by jury, right to be represented by counsel. The right to confront and cross-examine all witnesses called to testify against you. The right to produce evidence. The right to call witnesses in favor. The right to appeal this matter to higher court if you lose, and the right to depart of the Commonwealth to prove unreasonable without pleading guilty to charge against you. Understand that by entering a guilty plea, then you give up those rights. You understand that?
Yes, sir.
I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I do not have to accept any recommendation. Prior to accepting any recommendation, I will await a pre-sentence investigation report from probation patrol. In the event that you do not accept the commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea and proceed to trial. Mr. Stockton, what is the recommendation?
Mr. Bruce will plead guilty to possession of a controlled substance, first degree, receive a sentence of 3 years, serve 30 days in jail, probated for 5 years, supervised. You'll also plead guilty to failure to maintain owner insurance on a motor vehicle, $500 fine and cost, receive credit for time served, be released at final sentencing. The 5-year sentence shall run, the 3-year sentence shall run concurrently with Casey Circuit Court Indictment 24 CR 5.
Is that what you agreed to?
Yes, sir.
And you understand that by entering this plea, it has a felony conviction that could enhance the penalty of sentences if you have felonies in the future. You understand that? Now,
Yes, sir.
about fine and court costs. We don't know for sure, but we'll get it back to you. It's somewhere north of $700 or something like that. Now, we'll schedule, let me do the rule later.
25th.
Yeah, let's, do
Is there
the,
any way I could be final sentence today? Because I already served that 30 days times 2. And
Like we did the plea today, so we could send him the 25th, Your Honor, he'll have to have.
And Judge, and I don't believe a PSI was done in the case.
we'll have to do a pre-sentence investigation report and we'll go ahead. The reason we did it here today is so we could get it behind you on April the 25th in Burksville. So you'll be sentenced on April the 25th in Burksville and either be transported down there. Okay, is there anything else I need?
The signature, Judge.
Yeah,
Yeah.
so,
that's your signature on there, sir?
but do I really got to sit here 2 more weeks? Can I be released today?
No,
Can we
you're
make
gonna
it
have
back to court?
Yes, and you'll be released on the day of sentencing over there. We moved it over here so we can save you a month, okay? Okay.
Stephen, they will be over to see you, probation and parole will be over to see you to do the PSI interview.
Okay.
They came to
thank
see
you
me
very
already.
much. Okay, Cesley Davis. Are you Cesley Davis?
Yes, sir.
Were you born in 1994?
Yes, sir.
Last 4 digits of your social security number, 3327.
Yes, sir.
This is Cumberland Circuit Court case number 23 CR 0070.
Judge, we have a felony plea.
Okay. A motion's been tendered, Ms. Davis. It says you wish to enter a plea. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person named in indictment number 23 CR 007?
Yes, sir.
Is your judgment impaired today in any way? Is your judgment impaired? Do you know what's going on?
I understand what's going on. It's not impaired, sir.
Okay. Have you discussed this matter with your attorney and are you satisfied with his advice?
I've discussed it with him. I am confused as to why I would
Do
have to
what?
wait until the 25th to be released based on some DSI paperwork.
I'm having a hard time hearing you. Will you lean toward the microphone and start again?
I am fully aware of what we were being told today. I'm hoping, though, that I don't have to wait here until the 25th, just based on PSI paperwork. If there's any way we could get my paperwork in here today so that I can.
Wait a second. I asked you if you're satisfied with his advice.
And I said yes, however, and we were all interrupted and you couldn't understand
Okay,
me.
well, it's either yes or no, and I can put your
Yes,
sentencing off for another month if you want to.
Cecily, if you want to get out the 25th, you need to quit trying to get out today. You're going to have a PSI done like I told you.
That's what you told me, that it would be today. I would get the paperwork today.
Okay, I'm gonna put her.
I understand that.
Well, there's no putting it off because there's a trial set April 29th. She don't enter the plea.
Cecily, you're about to have a trial and not get out at all, so you need to get out the 25th like I told you.
I'm saying Okay, I understand that. Yes, I signed the paperwork.
What's she charged with?
She's charged with, taking her aunt's automobile and,
That's
they
the
ain't got
only
her car.
charge.
Yeah, and then I had to, have her extradited from Nashville. And so,
Let's just give her a trial.
okay.
I just don't see that she's gonna be amenable.
I don't have enough time to hire an attorney between now and the 29th. I do not have time to hire an attorney between now and the trial date for the 29th.
What day is the trial set for?
It was set for
We can
April
have her
29th.
appear with an attorney April 25th and get another trial date for her if you want to. If you want an attorney, different attorney.
I said I already pled guilty and no one understands what I'm saying. I pled guilty. I want to go ahead and do what we agreed based on that paperwork. That's all. I understand we're on a computer. It's very hard to understand what we're all saying. But I'm saying I agree with what me and Pennington discussed here inside of Adair County Regional Jail.
Okay, are you satisfied? Let's go back. Are you satisfied with the advice of your attorney?
Yes, sir.
Okay, have you reviewed the evidence the Commonwealth has against you, and are you fully informed about the case?
Yes, sir.
Okay, you understand that you do not have to enter a guilty plea today. You have
Yes,
certain
sir.
rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything. You have a right to speedy trial by jury. The right to be represented by counsel at your jury trial. The right to confront and cross-examine all witnesses called to testify against you. The right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to higher court if you lose. You have the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of the charge against you. That you understand by entering a guilty plea today, you give up all those rights. You understand that?
Yes, sir.
I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I don't have to accept the recommendation. Prior to accepting your recommendation, I will await a pre-sentence investigation report by probation and parole. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea and proceed to trial. In other words, I cannot give you any more than you've agreed to. You understand that?
Yes, sir.
Now, what is the Commonwealth's recommendation? And she is having, she says, a hard time hearing it, so you're gonna have to speak up. Go ahead.
Miss Davis will plead guilty to theft by unlawful taking over $1,000. She'll receive a sentence of 5 years probated for 5 years supervised. She'll receive credit for time served and shall be released at final sentence. The defendant shall have no contact with the victim by any means and voluntarily agrees to remain outside the Commonwealth of Kentucky. She shall obtain gainful employment or do a minimum of 30 hours community service per week until employment is obtained. And all evidence in this case will be destroyed and pay court costs at the discretion of the court.
And I'll tell you what the court costs are at sentencing on that day. They're not much, they're under $200.
It'll be transferred. It's a felony.
Is this your signature? Ma'am, on the agreement, is that your signature?
Yes, sir.
Okay. Well, I'll accept the plea order, pre-sentence investigation report, and have sentencing over there on what day?
25th.
April
25th.
April the 25th. So you need to have someone available to pick you up that day because it says you will release the sentence.
Thank you so much,
Very
sir.
much.
Thank you.
Probation and parole will be over to interview you to prepare your PSI.
Yes, sir. Thank you.
That finishes. Okay, Dare County, you may be excused. Thank you.
Thank you.
Okay, the grand jury is ready. You want to bring the grand jury in? And then we're ready to go to Clayton County House at all. All rise. Okay, everyone can be seated. Now you have the indictments, ma'am. I would assume that you are the foreperson of the grand jury. Is that right?
Yes, sir.
Everybody can be seated, please. Have 9 or more of you agreed on each one of the indictments you have in your hand?
Yes.
You give them to the bailiff. Madam Foreperson, ladies and gentlemen of the jury, everything appears to be in order. We will review these and either issue warrants or summons. If these folks are already incarcerated, we'll issue summons. If they are in all probability, if they not, we'll probably issue warrants and we'll set a bond sufficient to assure their attendance here, or if there is a case of danger, assure the protection of the public and make sure they appear. The next time that y'all are to be here will be May the 2nd. May the 2nd, okay? So thank you very much for your service. I want to remind you that anything you hear in the grand jury, you shall keep confidential for your safety, the safety of the public, okay? You are excused. All rise to the grand jury, please. Everybody can be seated. Okay, let's go to the Clinton County Jail. Clinton County Jail. The first person will be Tony Albertson. I'm gonna take about a 2-minute break before that. Tony, I'll be right with you. Yeah. Yeah, I'll be questioning.
I think the jury instruction. But they on computer, they won't be a hard.
We did not make seen it or come back, we made it available for the people. Yeah.
Okay, let's go back on the record, please. Commonwealth versus Tony Albertson for sentencing. Are you Tony Albertson?
Yes, Your Honor.
Born in 1984?
Yes.
Last four digits, social security number 9471. We're here on 21 CR 004. Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole, Tony?
I don't. That's the papers y'all filled out. Yeah, I filled one out.
Tony, the document you and I went over, this is James.
Okay.
Counselor, is it everything in there correct?
It is, Judge.
Is there any reason this gentleman should not be sentenced?
No, Your Honor.
Commonwealth, he shall be sentenced to 2 years to serve. Pretrial diverted for a period, and that diversion was voided. Okay, so he now shall serve 2 years. Is that correct?
Yes, Judge.
Okay, thank you very much, Tony. James Armstrong.
Yeah.
James Armstrong. Are you James Armstrong?
Yes, sir.
This is 24 CR 0013. Mr. Armstrong, what year were you born?
63.
And the last four digits, social security number 8043.
Yes, sir.
You're here today for the purpose of arraignment. Your attorney, David Cross, is here. You have a right to remain silent. The grand jury of Clinton County has returned an indictment charging you with assault in the second degree. Do you understand what that charge is? I'm not asking you whether you're guilty or not. Do you understand what that charge is? Assault in the second degree.
Yeah.
Okay. Mr. Cross, you acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter a plea of not guilty, reserving all pretrial motions.
I do, Your Honor.
Now, we are signing a reciprocal discovery order that the Commonwealth shall give you attorney all the evidence that they have to help you prepare for the case.
Your Honor, I do need to advise the court and Mr.
You need to
Stockton.
speak up a little bit.
I want to advise the court and Mr. Stockton of something, and I want Mr. Armstrong to hear this too. It is my understanding that this case may be subject to a supplemental indictment, making it a more severe case. I had attempted to make terms to represent Mr. Armstrong in this case because I've represented he and his family about as long as I've represented any family in this county. I may not be able to continue representation for various reasons, but I think we ought to set it for a negotiation day, and Mr. Stockton and I can talk about it, and Mr. Armstrong and I will with his family.
The
But
negotiation day is set for April the 26th at 9 a.m. You need to get a transportation order ready for that.
he's here.
Well, if he might not be here, but
Oh, okay.
I just, what I'm saying is you need to be aware of where he is. And then on May the 2nd is the next court date. Both of them are conditions of his bond.
Thank you, Your Honor, and I hope to be able to continue his representation, but we just don't know.
Terry Britt. Terry Britt. Commonwealth versus Terry Britt. Are you Terry Britt?
Yes, sir.
Mr. Britt, were you born in 1975?
Yes, sir.
Last four digits of your social security number are 9053.
5'8".
9058. Okay.
Yes, sir.
All right. And this is 23 CR 00055. You're here today for sentencing. You had an opportunity to look at the pre-sentence investigation report done by probation and parole.
Yes, Your Honor.
Is it substantially correct?
Yes, Your Honor.
Okay. Mr. Cross, the reason this gentleman should not be sentenced today.
No, Your Honor, I believe we can proceed.
Upon a plea of guilty possession of handgun by convicted felon, the defendant shall receive a sentence of 5 years, serve 171 days in jail with the balance probated for 5 years, supervised, and receive credit for time served. Shall be released at final sentencing on April 11th. Now, when do you want him to be at the probation parole office?
On the 16th at 8 a.m. Central Time.
Did you get that, Terry?
Yes, sir.
April 16th. What day of the week is that?
This coming Tuesday,
Tuesday, April 16th at 9 a.m. Central Time.
8 a.m. Central.
8 a.m. Central Time. 8 a.m. Central Time. At the Monticello office.
Yes, sir.
You got that, Terry?
Yes, sir.
What are court costs in this case? Court costs $155. I'll allow you to pay that either all at once, or you can pay it $30 a month. First pay today, okay?
All right. Thank you, sir.
Thank you. Keaton Cross. Are you Keaton Cross?
Yes, sir.
This is 24 CR 0022. Mr. Cross was born in 1999.
Yes.
Last four digits of your social security number 4226.
Yes. No, 1745.
Last four is 1745.
Yes.
Okay, you're here today for the purpose of arraignment. You have a right to remain silent. The grand jury of Clinton County has returned an indictment charging you with criminal trespass in the 3rd degree, possession of marijuana, possession of methamphetamine, and possession of drug paraphernalia. You understand those charges?
Yes.
Okay, I'm signing a typical discovery order, which requires the Commonwealth to provide your attorney with the information they have concerning your case to help prepare for defense. I'm ordering you to be here.
Judge, if I may, I think the Commonwealth may have an announcement regarding this case or how we're proceeding.
Will you acknowledge receipt of the indictment with formal reading or an interplea not guilty reserved all pre-trial motions? Okay.
Yes, Your Honor.
He's going into drug court through the Cumberland County case. And if he completes that, then I very well may dismiss the Clinton County case, but we need to wait and see.
So you just want to continue this generally,
Yes.
arraigned, and he's in jail under the Cumberland County?
Yes, and he won't be released until he's oriented for drug court. Cumberland
And
County.
he's already received those dates. I think it's April,
Okay.
Keaton was it 24th and 25th?
The 25th be released, the 26th I go for orientation.
What was he?
They're both possession cases, Your Honor.
Okay. Okay, Keaton, what they're saying is once you get oriented and that sort of thing, if you successfully complete the Cumberland County Drug Court, that they'll dismiss this case over here. So I'm gonna continue this case generally. Okay?
Thank you, Judge.
It's still laying out there, so.
Others told me that it's still on this case, that he does not have a warrant, he wasn't the only one. How's your warrant?
Well, there should have been. It was a motion. It was a vote.
About probation.
That's just not.
Jesse, when he got arrested on this new charge, he had a violation in district court and he was held on it, and you filed a motion without him being lodged.
Okay.
Seems like he's got a whole lot of violating going on all these various things like.
Well, I'd ask that there be a warrant issued in the Cumberland County case and he be held until he's released to drug court. Because there should have been one issued when the motion was filed, and I guess probation
do
just didn't
that.
ask for one over there.
I guess they'll transfer him to the Dare County then to be held.
Well, you want to issue a warrant here in Lincoln County then?
There's no bond.
It's
no
no,
bond
wait,
on this
it's
case.
no bond on this one.
Let's leave it that way.
Yeah, I
Get
think-
that drug court.
No word on.
No, just leave no bond here, and when he gets in that drug court over there, I'll release him. That way he can say.
Judge.
Dylan Flowers. Dylan Flowers. Are you Dylan Flowers?
Yes, sir, Your Honor.
Okay, were you born in 1991?
Yes, sir.
Last four digits, social security number 4226, correct?
Yes, sir, Your Honor.
Okay, you're here for sentencing in 18 CR 0029 and 18 CR 0073. Have you had an opportunity to look at the pre-sentence investigation report?
Before you start on that, maybe you had a minute plate on this.
Yes, we need the amended plea paperwork entered. That's to Mr. Flowers' benefit because it reduced it from a C felony to a D felony.
Correct.
Yes. Did you get it signed?
Did I get the amended stuff?
Let me see.
Yeah,
When you sent it to-
right to your email.
Which day? There we go. No, we'll get it done. I'll get it done if we can revisit here in a little bit. Yeah, well, what they didn't send us.
It's on the email. It's got file.
I'm sure you did. It's just we get a lot of stuff. Oh, okay. Yeah, I remember. getting
March
that.
22nd.
Yeah.
Have
Okay,
you
that's
seen your
okay.
pre-sentence investigation report done the probation parole?
Your Honor, I don't believe he has because of confusion about the plea. So if we could send it down and I need to get him.
I don't think you can get all this done today. You know, I mean, it has to be an amended PSI and then an amended PSI.
Yeah,
No, I think Christy did it.
Yeah, because it was the PSI rider that caught the mistake in the plea.
So PSI is correct.
Yes.
I didn't understand that. Let me send it down to him, Judge.
Well, let him do that. Let me ask you, I don't think it's necessary to re-enter a plea. I just think that we can.
No, it's a diversion. He just needs to sign the paperwork.
Well, I think he just needs to acknowledge, you acknowledge on the record that the plea agreement previously signed will be amended. Just look at that. Do you think he needs to enter a plea again?
I don't think we need to go through the call.
No, not all of them.
Well, that's what I'm saying.
But there needs to be the signed paper.
Okay, they're reducing it from a B to a C or?
No, it's C to D because he wouldn't have been eligible for diversion with C. And we did, it was our intent to reduce it, but the paperwork was in error.
Well, they're gonna bring some paperwork down there, Dylan, for you to read, and then I'm gonna call you back up later in the day sometime, okay?
Thank you. I'll work with that.
Tyler Holland. He's in jail. Commonwealth versus Tyler Holland. He's in jail now.
Oh, wow.
He's 20.
He's been in that double car.
23 CR 0040. Are you Tyler Holland?
Yes, sir.
Okay, were you born in 1996?
Sir.
Last four digits, social security number 0698. Here
Yes, sir.
today, 23 CR 0040. What does Mr. Stockton have to say about probation?
Your Honor, we have a motion to revoke probation. He has an 8-year sentence on trafficking. He had 2 positive meth tests back to back, March the 4th and March the 14th. On that.
And Judge, I've actually tendered to the Commonwealth. Mr. Holland has been accepted into rehabilitation with Spark. He has a bedwetter. In fact, if the court being inclined, he can be transported tomorrow. It's, 2 substance abuse, violations, he didn't pick up new charges. Judge Willis asked him treated for this young man.
Your Honor, I will reluctantly agree, but I want to inform the court, Mr. Holland, I've dealt with Mr. Holland for several years. The only reason I didn't have a trial on him this past December was he was working at Cowboy Charcoal, and it's not his fault they closed the place. But I gave him a big break then, but this is kind of it. If he messes this up, I'm going to be adamant that he be revoked.
What sort of treatment place are you?
It's Spark, Judge, in Russell Springs.
Pretty big place.
We have quite a few there. They're actually supervised out of the Somerset office. The officers go there and see.
Okay, Mr. Holland, you got 1 foot in the penitentiary and one on the banana peel. You understand what I'm saying? You've had these dirty tests. Commonwealth has agreed to send you to this drug rehab. If you do not successfully complete that drug rehab, or if you violate in any way, you're gonna get revoked. You understand what I'm saying?
Yes, sir. I appreciate y'all for letting me have a chance.
Okay, well, get over there and work hard at it, Mr. Holland.
Thank you, Judge.
Yeah. Dennis Kempton. Dennis Kempton. Are you Dennis Kempton?
Yes, Your Honor.
This is 23CR0060. Mr. Kempton, were you born in 1974?
Yes, Your Honor.
Last 4 digits, social security number 8161.
Yes.
We're here on a pre-trial conference today. What's the Commonwealth episode?
We have a felony proven.
Mr. Kempton, a motion has been tendered that says you wish to enter a plea today. Is that correct?
Yes, Your Honor.
Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given?
Yes.
Are you the same person we identified when I called your name?
Yes.
Was your judgment impaired today in any way?
No.
Have you discussed this matter with your attorney and are you satisfied with his advice?
Yes, Your Honor.
Reviewed the evidence which the Commonwealth has against you.
Yes.
You believe you're fully informed about your case.
Yes, Your Honor.
You understand that you do not have to enter a guilty plea. You have certain rights under Kentucky and the United States Constitution. Before I can accept a plea, I need to know that you understand those rights.
Yes,
You have a right not to testify against yourself. No one can make you say anything. You have a right to speak your knowledge, your right to be represented by counsel. Right to confront and cross-examine all witnesses called to testify, but you right to produce evidence, or right to call witnesses in favor. The right to appeal this matter to higher court if you lose, the right to require the Commonwealth to prove without a reasonable doubt that you are really charged. Once you understand about hearing this plea today, you give up those rights. You understand that?
Yes.
Now, I may consider the Commonwealth's recommendation, but I live by the range of sentence provided by law. I don't have to accept the recommendation. Prior to accepting the recommendation, I will read the pre-sentence investigation report and information flow. In the event that I do not accept the Commonwealth's recommendation, decide to impose a harsher sentence, you have the right to withdraw your plea and proceed to trial. Ms. Gordon Anderson, what is the Commonwealth's recommendation?
Yes, Your Honor. Upon a plea of guilty to burglary 3rd degree, the defendant shall receive a sentence of 5 years, probated for 5 years, supervised. The defendant shall pay restitution in the amount of $310 at a rate of $100 per month plus 5% clerk's fee, with the first payment being due within 30 days of being released from incarceration and payable on the same date thereafter. Restitution shall be paid to the Clinton Circuit Court clerk. The defendant shall receive credit for time served and shall have no contact with the victim or victim's real property by any means. The defendant shall obtain gainful employment or do a minimum of 30 hours per week until gainful employment is obtained. Defendant agrees to have any and all evidence forfeited and destroyed in a manner that is consistent with the laws of the Commonwealth and the holding agency in both the above style cases.
Mr. Kevin, is that what you agreed to?
Yes.
Are you pleading guilty?
Yes, Your Honor.
Because you are guilty?
Yes.
Okay. You're doing so of your own free will?
Yes.
Knowing your constitutional rights explained, is it still your desire to give up these rights, enter plea guilty to the charges and allow the court to fix your punishment according to law? Is that right? Do you understand if you're entering a guilty plea today, any future convictions will be enhanced as far as your range of penalty? Do you understand that?
Yes.
Is that your signature on there?
Yes.
I will accept the plea, order pre-sentence investigation report, and order of sentencing on May 7th.
Thank you, Judge.
Andrew Murdoch. Andrew Murdoch for arraignment. Are you Andrew Murdoch?
Yes, sir.
Were you born in 1999?
Yes, sir.
Last four digits, social security number 1746.
Sir.
Okay, you have a right to remain silent. You're here for the purpose of arraignment. The grand jury of Clinton County has returned an indictment charging you with trafficking controlled substance in the first degree and possession of drug paraphernalia. You understand those charges?
Sir.
I'm signing a reciprocal discovery order requiring the Commonwealth to give your attorney all the information they have about your case. Counselor, do you acknowledge the identity of your client, receive indictment, waive formal reading and arraignment, enter a plea of not guilty, reserving all pretrial motions?
Yes, Your Honor.
Schedule this gentleman to appear here for negotiations on April the 26th, and then on May the 2nd to appear here for his next court appearance, both of them at 9 a.m. Both of them are conditions of the bond.
Andrew, I'll be back over to see you soon about what you talked about this morning.
Yes, sir. Thank you.
Okay, Daryl Murphy. Daryl Murphy. Are you Daryl Murphy?
Yes, sir.
Okay, this is 18 CR 0015, 00115, and 19 CR 00009. You're here on a probation revocation motion. You're born in 1974, is that correct?
Yes, sir.
The last four digits of social security number is 4535. What does the Commonwealth have to say about Mr. Daryl Murphy?
Your Honor, he has a 5-year sentence on criminal possession of a forced instrument. The last violations are because he didn't report in March or February. He was listed as absconder. We obtained a warrant and filed a motion to revoke probation. I think we previously filed a motion to revoke probation back in 2019. He was placed in drug court. And then he's had multiple violations over the time. So the Commonwealth's asking he be revoked.
Stipulate?
Yes, Judge.
Okay, you'll probably be eligible for parole pretty soon.
That's what we had discussed today, sir.
Okay, I'll revoke you, Mr. Murphy, and then you should be eligible for parole. Conditions of parole are not as stringent as those of probation, and maybe you can comply with those when it happens, okay? Thank you very much. Christopher Young. Christopher Young. Commonwealth versus Christopher Young, 23 CR 0018, 23 CR 0023, 23 CR 0021. Are you Christopher Young?
Yes,
Are you
sir.
Christopher Young?
Yes, sir.
You born in 1995?
Yes, sir.
Last four digits to social security number 7276.
Yes, sir.
Well, you're here today for sentencing. Have you got to review the pre-sentence investigation reports done by probation and parole?
Yes, sir.
Okay. Are they substantially correct?
Yes.
Is there any reason, Mr. Cross, that gentleman should not be sentenced.
No, Your Honor, we're ready to proceed with sentencing.
Pretrial diversion was voided on March seventh, 2024. On 23 CR 0018, possession of controlled substance first degree and possession of controlled substance opiates, the defendant shall receive 3 years. On 23 CR 0023, possession of controlled substance first degree meth, the defendant shall receive 3 years. On 23 CR 0029, possession of controlled substance heroin, he shall receive 3 years. In promoting contraband first degree, he shall receive 5 years. However, the sentences in 18, 23, and 29 shall run concurrently for a total of 5 years. Okay?
Your Honor, I'd just like to advise the court on behalf of Mr. Young that all of his previous offenses are basically based on being a user. We've had some discussions about rehab, and the Commonwealth at this point in time is not in agreement with that, but he's expressed an ardent desire to go into a long-term rehab at some point in time, because he's never been, and I'll be at some point in time bringing a motion in that regard after I speak to the Commonwealth.
Just for Mr. Young's benefit, he was in drug court, and he had a lot of tests that were either diluted or highly diluted, and the only person he was cheating was himself. And when he realizes that, he might get some.
Okay, thank you, Mr. Young.
Yeah.
Now, we've got some that we passed over earlier. Is Anthony Richardson down there?
Yes, he is, Your Honor.
Anthony Richardson. For arraignment. Are you Anthony Richardson?
Yes, sir.
You're here on 24 CR 0020. Were you born in 1998, Mr. Richardson?
Yes, sir.
And last 4 digits, social security number 1777.
Yes, sir.
You have the right to remain silent. You represent this gentleman, Mr. Cross?
Yes, I do, Your Honor.
Okay. The grand jury of Clinton County has returned an indictment charging you with public intoxication, possession of drug paraphernalia, possession of controlled substance in first degree methamphetamine, trafficking controlled substance first offense. You understand those charges?
Sir.
Mr. Cross, you acknowledge the identity of the pursued indictment. For formal reading and arraignment, here plea is not guilty, reserving all pre-trial motions.
I do, Your Honor.
I'm signing the reciprocal discovery order that will require the Commonwealth to provide your attorney, Mr. Richardson, with information concerning your case. You're scheduled here on April the 26th for a negotiation at 9 a.m. at 9 a.m. on May the 2nd. For your first court appearance, both of them are conditions of your bond.
Your Honor, may we address bond briefly?
What is his bond?
20,000 surety. I think he's having issues finding someone like that.
Well, we made a bond of a lesser amount in district court, and we did that, Your Honor, so Mr. Richardson could move to Georgia where he is employed. And like a lot of young people in this county, if they have trouble with their decisions here, the best doggone thing for them to do is get their butt out of here and go to work somewhere else. So that's what he's doing. So if we could reduce that to perhaps a $5,000 surety, I believe his father would be able to sign it. That's all he's got here. And I don't believe Mr. Stockton really opposes that.
I really don't, as long as we'll make his court dates. He has a limited criminal history. So.
Well, he'll need to sign a waiver of extradition.
It'll be fine.
Need to get a waiver of extradition. Now, is his dad live here?
Yes.
Well, is his dad doesn't want to sign a $20,000 bond, or he doesn't?
Well, Your Honor, he's worth $5,000. He's not worth $20,000. You know, with what he owns real estate, but you know, there's equity in it, but
I'll approve him for a $10,000 surety.
Okay.
Myself.
And I believe he'll sign that if I ask him to.
And then Young man, will you waive extradition to come back so we don't have to extradite you from Georgia, wherever you are?
Yes, sir.
Okay, well, we'll get him a document down there. He's done that in open court.
And I'll get hold of Tommy this afternoon, okay, and I'll tell your mother what's going on, okay?
All righty, thank you.
I'll get you out tonight.
We got John Tucker down there. John Tucker? Are you John Tucker?
Sure.
Were you born in 1984? Were you born in 1984?
Yes, sir.
Okay, the last four digits of social security number 2409.
Yes, sir.
Okay, you're here today for sentencing. Have you had an opportunity to look at the pre-sentence investigation report in 23 CR 0054 and 24 CR 0024? Have you seen that?
Yes, sir.
Is it substantially correct?
Yes, sir.
Mr. Cross, is any reason this gentleman should not be sentenced today?
No, Your Honor, we're ready to proceed.
On there.
That individual first.
Upon plea of guilty to information indictment number 24 CR 0024 with the charge of unlawful transaction minor second degree, the defendant shall receive a sentence of 5 years, serve 60 days, the balance probated for 5 years, have no contact with the minor. Defendant shall receive credit for time served, shall have gainful employment. Now, what happened to the other indictment?
Yes, that's correct.
23 CR 0054 was dismissed in its entirety
Yes.
with prejudice.
Yes.
What is the court cost in this case?
$155.
Okay, you should pay $155, $50 a month, first payment due 30 days after you're released. How many days does he have in?
His been since last Friday, he owes 60 days total, so he's still got a ways to go.
Yeah, he's got a ways to go.
Okay,
He's been in about a week.
Got 7 days.
So, about 3 days, just. Yes, we do. And a month. And hope. No,
is this, Mr. Stockton, is this a case that involves registration?
it does not.
Come up and tell me a little bit something about this. No, don't come up here. I'm talking about Mr. Stockton coming in.
This was a case where we had Snapchat photographs from Mr. Tucker to a minor. We did a search warrant to Snapchat. The minor child says there was some conversations Mr. Tucker was trying to elicit from him, but when we got the search warrant back from Snapchat, we only had the picture of Mr. Tucker. So that's the reason for the modification of the plea. And that's the reason we did unlawful transaction with the minor rather than the sex of the registration. Now, and the victims were the mother and the father.
Are they satisfied?
They're satisfied.
Okay, now does he have to be meet with probation and parole?
I'll get him paperwork before he's released.
Okay. Mr. Tucker, you need to spend your time there thinking very carefully of what could have happened to you on this case. I don't want any response from you, but probation and parole will be overseen. Thank you very much.
Call me if you have
Is
questions.
there anybody else in, I guess, we have anybody else down in?
We've got Dylan Flowers, and I'm hopefully bringing his paperwork up briefly very soon. And Mr. Stockton, I have one other Cumberland County case we want to address sometime this morning.
We have a felony plea in it. It's set for trial the 16th of April. And we're going to be trying the case. So we can enter the plea in this one. We can try the case in Monroe County next week.
Where is the defendant?
He's here.
Okay, well, let's pull a Cumberland County case. Well, we're waiting for the paperwork to get back from the jail. This is Cumberland Circuit Court meeting by agreement in Albany. Commonwealth versus Brett Davis, 23 CR 0028. Are you Brett Davis?
Yes, sir, Your Honor.
Motion's been tendered that says you wish to enter guilty. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
You're the same person that previously was identified in 23 CR 0028. Is that correct?
Yes, sir.
Is your judgment impaired in any way today?
No, sir.
Have you discussed this charge with your attorney and are you satisfied with his advice?
Yes, sir.
Have you viewed the evidence Commonwealth has against you and you could fully informed about your drugs?
Yes.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can say you're guilty, I need to know that you're fully understand your rights.
Yes.
I'll go over them and I'll ask you about them. You have a right not to testify against yourself. No one can make you say anything. Right to speak, trial by jury, right to be represented by counsel, right to confront and cross-examine all witnesses, called to testify against you, right to produce evidence, right to take witnesses in favor. Right to fill this matter, have the power to hold you lose, and right to part of the Commonwealth, including on reasonable doubt, which you are guilty charge against you. Understand that we enter your guilty plea today, you give up all that right. You understand that?
Yes, sir.
I may consider Commonwealth's recommendation, but I may apply to sentence private law. I don't have to accept the recommendation. Prior to accepting the recommendation, I will wait a pre-sentence investigation report and probation for in the event that I do not accept the Commonwealth's recommendation, decide to impose a harsher sentence, you have the right to withdraw your plea guilty and proceed to trial. You'll step to your left, Mr. Stockton. What is your recommendation?
Your Honor, Mr. Davis will plea is charged to theft by unlawful taking over $10,000 for less than $1 million. He'll receive a sentence of 10 years, probated for 5 years. He'll pay restitution amount of $48,775 at a rate of 6% interest through the Cumberland Circuit Clerk's office. He'll pay $10,000 by April 24th, 24, with the balance paid in monthly payments of $1,000 per month, being due on the 24th day of each month thereafter. Restitution subject to a 5% clerk's fee. Have no contact with the victims, maintain gainful employment, and abide by all laws of the Commonwealth of Kentucky. And I didn't put in here, but of course he'll pay court costs at discretion of the court.
Yeah, I'll just announce what the court costs are on the 25th.
Okay.
The order of pre-sentence investigation report. Now you come, is this what you agreed to?
Yes, sir, Your Honor.
And are you pleading guilty because you did commit the acts charged in the indictment?
Yes, sir.
Know your constitutional rights, still your desire to proceed, and allow the court to fix your punishment within the limits allowed by law.
Yes, sir.
You understand that by entering this plea, any future convictions you have could be enhanced as far as your range of penalty. Do you understand that?
Yes, sir.
Is that your signature on the document?
Yes.
I'll accept the agreement, order of pre-sentence investigation report to be done. Sentencing will be on April 25th. You want to let them take that back over to Cumberland County Williams?
He will see the probation officer, he'll do the contacts. Go to Daren. Yeah. Check on him.
What about Anna Hogan? What is that?
I don't know, Your Honor. I referred to the docket.
She was, must have been an add-on, but I don't, it's a probation revocation, but I don't see you going up and file a motion as long as you're out on.
I don't either, because we didn't pull the file, so I don't think we
I'm
filed
gonna
it.
ask probation parole officer.
You didn't file it. I hope you-
Well, I have something done.
Judge, we don't have any idea why it's on. We'll have to look at it and see. Is the clerk know? You all got the file in here?
I looked at it. In my email, I didn't see all the
It was dismissed, the case was dismissed, April 18th. So it should be. Well, everything or split this case, this meant you, unless you file a petition for each thing. Okay. Mr. Smith is here in court, Your Honor.
Okay. Let's go Columbia.
Cody Smith. Cody Smith. Okay, Mr. Stockton, his attorney said he couldn't be here today. What's the issue?
Mr. Wittenberg's in a right problem.
Yeah, but with this gentleman, what was the issue?
He's been charged with a new felony, assault in Haley Harbor. And I filed a motion to revoke his bond.
Has he been indicted on that?
Not yet.
All right, I'll take them.
They appear in front of the grand jury.
I don't know if they, no, he didn't appear today because I'm getting special prosecutor because I'm prosecuting his Harbor in the reckless homicide case. But I can handle this motion to revoke bond. Use her as a witness, my office can, but I will still be prosecuting Mr. Smith on the other victim's case, and the special prosecutor will have him on this case. I don't know if Mr. Smith was sober or not today, if he understands what's going on.
Yes, sir. I ran here on foot because my attorney told me not to come.
Well, I got a report from Mark Bale that you kicked in Chad Ledbetter's door and he drove you today.
No. That's my buddy.
Well, there's only
Well,
one,
I ain't saying-
wait a second. There's only one problem.
Chad Ledbetter's my
Be
buddy.
quiet.
Okay, yes, sir.
There's only one problem.
Yes, sir.
This was one you heard him tell you. Clerk told you to be here today, and you weren't here. So whether your attorney could be here or not, you were supposed to be here. The clerk told you to be here, and you did not come. Okay? Now, I'm going to appoint the Office of Public Advocacy to step out for a second and talk to this gentleman before I do anything to him. You go out here and talk to this gentleman, the attorney.
Okay, he's going to see it's on the way. You know, she can be a son.
Will you get a test ready? Just so happens that way.
Yeah.
I'm sure I correct in this respect.
The latest Scott Grew has rejected Kentucky. And
Martin's under consideration.
well, they've got Wayne Carver in consideration, and I think Martin's better off staying where he is. He got one Carver. Oh, and he coached Little League over here for years and years. He's a guy that wins. Well, of course, they can't talk to Billy Donovan.
Why?
Because he's in the NBA, he'd have to quit. It's crazy. Yeah. See, he can't negotiate while he's playing. And you've got to have somebody that's daddies, because the portal.
Nah, they don't have to. I think it's below the.
Well, it's what they're fixing to do. Yeah. Yeah.
We're going to be fixing.
oxycodone, meth, Suboxone. Is what I'm showing, sir.
Okay, take him into custody.
Your Honor, I'd ask to stay in custody because we have a hearing on his bond.
His next rule.
It's not even, I just took 1 year to get Judge Williams, you know?
Don't say anything else.
Okay, thank you.
Okay, now we got one other case coming up. Thank you for studying in.
You know,
That's not what I told him.
We'll schedule him for next rule day.
We need to do a better rule against this case, that bond revocation is set at 1 o'clock, like 7. And Mr. Whittenberg says he could be here on the afternoon of the second. That's what his staff said. That's why I told Jennifer to do an order, if that's all right with the court.
Send him at 1, but when Mr. Wittenberg comes over here, y'all need to remind me to tell him that we got one rule day a month. And if he can't schedule around one morning a month, then we need to practice it. Everybody else does.
Bond revocation here.
Please, for me, second.
We'll check. She's a little bit, so, sorry.
Okay, we're back on the record, please. Commonwealth, Kentucky versus Dylan Flowers, 18 CR 00129 and 18 CR 0073. Are you Dylan Flowers?
Sir, Your Honor.
You born in 1991?
Yes, sir, Your Honor.
Last four digits of your social security number are 4226.
Yes, sir, Your Honor.
Now, we're here on a sentencing. Previously, the plea that you entered had denominated one of these felonies as a Class C felony inappropriately. Isn't that correct, Mr. Stockton?
That's correct.
And it was changed to Class D felony?
That's correct.
And you've been apprised of that, is that correct? Sir, you told that they reduced it from a Class C to a Class D felony? That's a lesser offense, so you don't have any objection to them making a lesser offense, do you?
No, sir, Your Honor, I do not.
Correct answer. Okay, have you had an opportunity to look at the pre-sentence investigation report done by probation and parole?
Yeah.
Is it substantially correct? You need to back away from the camera so I can see you.
Sorry, I was doing that. I couldn't hear real good. Sorry.
Correct, is it correct?
Is what you looked over this morning.
Oh,
Is it
yeah,
okay?
yes,
Is it
yes,
right?
sir. I didn't know you was talking to me, Your Honor. I apologize.
He said, what?
You didn't know he was talking, you was talking to him.
Okay, Dylan, is this correct?
Yes, sir, Your Honor.
Counselor, is any reason this gentleman should not be sentenced?
No, Your Honor.
Commonwealth, he shall receive the 5 years on each case to run concurrently. Pretrial diverted for 5 years, supervised. The defendant shall have no contact with the victims and shall not be permitted on the Shirley White farm. Okay, on the 3/7, pretrial diversion was voided and formal sentencing was scheduled today, so he shall receive 5 years, is that correct?
Yes.
Okay, so I sent him 5 years. With the same conditions, when he gets out, he gets parole, set the same conditions, staying off those properties.
Yes, sure.
Okay, thank you very much.
Your Honor, I'd like to address probation briefly. Mr. Flowers has never been in a long-term rehab facility.
I will take a look at that at shock.
Thank you. Dylan, is this your signature?
Yes, sir.
I'll probably be opposed. He had 2 years.
We'll talk about it then. Okay. Okay, there's anybody else down to jail? If not, excused. That concludes the morning session. We'll come back at 1, is that correct?
I'll do it. I'll work.
He's
Going back in session, the Honorable David L. Williams preside. Make sure all your cell phones are off.
Thank you. Everybody have a seat. Cabinet versus Brewer.
Judge, in this case, we have an order, for medical support, provided,
Willis versus Brady.
Judge, we have an agreed order to enter to the court.
Cabinet versus Brit.
Judge, the parties are here in that case, so.
Have them come around.
Brett? Sir. Judge, in this case, a complaint was filed against Mr. Britt and was served on 3/12/24, and no answer had been filed. And this was a motion for default judgment based upon one child, the age of 5, and the amount would be $522 a month, what we would be asking for. I don't know if you want to put Stephanie under oath and have her testify to what I just said, or.
Or you want to challenge that? Were these parties married?
Yes.
They were married at the time. And did the divorce decree have anything in it?
No. You've not got to that point yet, have you?
We have to do.
Yeah, not your honor.
The divorce decree is not final?
No, just separated. Yeah.
Okay. Where do you work, sir?
That's the food.
What?
Tyson Foods.
And you?
Dollar General Market. Dollar General Market.
Well, you can show them the calculation.
I did something with my lawyer trying to get over that custody of my child. I don't know if like we filed some papers or something. She's at like.
Was that, is that based on following the presumption of 50/50?
This would not be, does the child have a medical card? If the child has a medical card, we actually can't adhere to those figures. Because the state's helping provide for the child. Otherwise, we could do the 50/50.
I just want to know if how they were calculated.
Yeah, it's not calculated to that.
How much of that does the state get?
The state would, it would all go to the mother.
Doesn't seem to be real logical. I can understand why the state would keep the calculation from being like that. What if, when they get their divorce, what if I said child support amount lower than that? What does it do?
So go for that.
You have to go with what.
Well, I'm not saying I'm going to, I'm just
Right.
trying to find out what the deal is. How far back are you going on the 522?
Just starting this month.
At least there's not a marriage. Who is your lawyer?
Eric Bill.
And yours?
She's under David Cross.
So there's one. Action.
He hadn't
She
filed.
said she's gonna.
He
say
hasn't
something
filed.
in.
They haven't filed yet. I'd go over there and check on that, and you need to lawyer up. You know, so. Okay, well, I'll sign it for now. It can be modified during the divorce.
Actually, some of us.
Cabinet versus Carlton.
Judge, in this case, Mr. Carlton's ordered to pay $207 a month in current, 41 on arrears. Balance is $1,310.06, and we're asking that $500 be paid by May the 1st. We also got a tax interception, but that can take about 6 months, Judge.
Cabinet versus Duval.
Judge, in this case, Mr. Duval's ordered to pay 41 a month on arrears. And last payment, this is an arrears only, last payment was, it's been 4/23 of 21 and asking to pay 500 by May 1st.
Cabinet versus Hall.
Judge, this is an order amending child support down to $60 a month based upon SSI.
Cabinet versus Hurst, is that next or is there another Hall?
No, that's it, Your Honor.
Hurst?
Yeah. Judge, in this case, ordered to pay $200 a month on current, 50 on arrears, and asking pay $850 by May the 1st.
Kippenberg versus Hurst.
Yeah, that was that one,
That was
Judge.
one you just did.
Yeah.
I'd read Hurst previously, didn't read Children versus Hutchison.
Have an agreed order, Your Honor.
You versus Kentucky versus Calipari. Oh, no, that's a different docket.
Ouch.
Yeah. Cabinet versus Murphy.
We have an agreed order of paternity signed on that, Judge. Let me get something. Yeah.
Murphy. That's what we just
Yeah,
said.
that's the one we just said the paternity. Yeah.
Phillips. Cabinet versus Phillips.
Just got an agreed order signed on that, Your Honor. Kathy met with her here right before court and we altered the order there and she signed it, Your Honor, and lowered the amount we was asking for.
You can get a copy of it downstairs or next door here when it gets filed, okay?
All right, thank you.
Shelton.
Agreed order, Judge.
Shelton versus Shelton. Sloan versus Sloan.
Have an agreed order, Judge. Some criminal stuff.
Thrasher versus Thrasher.
Your Honor, in this case, Mr. Thrasher's ordered to pay $221 a month on current, $110 a month on arrears. We're asking $600 by May the 1st. We also got a tax intercept, but that takes about 6 months to be released for about $7,000.
And Thurman versus Thurman.
Just in the arrears only and asking $600 be paid by May the first.
What's the next thing in the docket? What time? Let's go off the record here then for a second. I will talk to Dire drug management is off the docket. Mitchell versus Mitchell.
Your Honor, Jim was not a party, he's a spouse, I would think.
You need to get back and send back here, sir.
Your Honor, this is our motion.
I read it. Yeah.
And I set it forth that this court, the last time we were here, was on the verge of and even stated that it was going to implement some limited supervised
Okay,
visitation.
well, I'm not gonna do that.
And then you had second thoughts.
Yeah, and I told you to go up there to the counselors up in Lexington, and you've said that the $8,000 is too much, right?
Well, it's not just, it's the time and the money. They said it would take several months to do and be thousands and thousands of dollars on both parties. And there's got to be a better alternative because I know.
Well, what is your better alternative that you suggest?
Well, Your Honor, if the court will order a specific one-time evaluation by someone in the area regarding the
Who
situation.
is that person?
Well, Ms. Huntley and I have trouble agreeing on things sometimes.
That does
We
not
think we both
surprise
need to do
me.
a better job,
It
don't we?
does not surprise me.
But-
When I ask y'all to draft an order, I never get one because you can't.
Well, we had an issue with it
Well, you always do. And, you know, this lady here is mortified of him, is not going to agree to anything, you know, and and if I was representing her, I couldn't get her to agree to anything.
Right.
He's got a very sordid history on this thing that, you know, and he might have changed, but I don't blame her in a way from being. And I'm not going to just go give some negative visitation on this. We're going to have something that's there because there's not going to be agreement about it. And as sure as I order something where there's no agreement about it, I'll pick up the newspaper and somebody's been killed. So that's just the way I feel about it, out of an abundance of caution. So I don't, you know, I don't think that, I didn't read a report from the folks in Lexington. I don't know why anybody else somewhere in the state hadn't started a cottage industry to offer that sort of services, but Judge Lovelace used to use them quite frequently.
Yeah, and I did tender, I prepared an order, I believe that's been tendered now, that I thought was exactly what you had ordered last night. I know Mr. Cross objected, to that, because I kind of copied him on the email, but I didn't send it for do it as agreed. And I understand, I think that is a problem. We have a minimal amount of places for custodial evaluations, but I think as far as what we're looking for, that's kind of what we need to do.
Well, you're looking for too much.
Okay.
You're looking for too much. He's not looking for enough. I'm looking for Mama Bear soup.
And we.
Just about right.
And we were even in agreement, I'm sorry, we were even in agreement with doing exactly what was ordered from the last, you know, what the first evaluation was. We thought that was slightly minimal, but we would agree to it, but they didn't want to do that either.
I have a suggestion.
Okay.
Perhaps the appointment of a friend of the court regarding this matter to implement something, or it could be a garden ad litem, might be the best way to proceed, because these folks, listen, I understand that her feelings for him. And I also understand how remorseful he is and how much he wants to try to reinstate his relations with him. They're not going to agree on anything right now. You're exactly right. But if we've got somebody that can take the time and look at this with an appointment and talk with Ms. Huntley and I and get the parties in, maybe we can get something done, but it's got to be somebody that'll work on it.
And Your Honor, I can discuss that with my client. We probably wouldn't object to something like that. I still think there's a need for a professional to give recommendations. I know as an attorney, I couldn't give recommendations for everything that would be needed.
Well, that would be a part of what this.
Wait a second. You need to tell people when they go in and out that door, hold it. Because it comes on the record and blanging around, so maybe we need to put a sign on.
And
I wasn't saying that we would avoid a professional evaluation. I just felt like the friend of the court or such individual could could determine what was appropriate and implement that and act as a go-between. I think that relieves the court of trying to figure that out.
And my client has looked at, and I'm not familiar with these places, some other places that she says offers custodial evaluations. One's in Franklin, Kentucky. All these places give price ranges, you know, and this place could start, it's available right now.
Well, I don't think the money is as big an issue as the time frame.
Well, and this one says it would be
Let
between, yeah.
me just tell you about the money. If it costs $8,000 and they split it, that's $4,000 each. That'd probably save them that much lawyer,
Yeah.
you know, to do that. So I think what we need to find is someone with a time frame. Yeah, I don't know, who's been involved in this, or any of the local lawyers been involved in this
No
case?
one but me or Mr. Mitchell, Mr. Garman, was the attorney prior to Ms. Huntley, and that's all, to the best of my knowledge.
Mr. Garman just got saved. I was looking at Mr. Garman, just thinking about how he might want to get involved in this. I noticed that he didn't have a panicked look on his face.
Somebody like Ms. Peran or somebody, I don't know.
I don't think Ms. Peran would know any of the parties involved in here.
I don't think so.
Yeah. Well, let me appoint, I'm gonna appoint her as a friend of the court. I
Okay.
think that's the best way to approach it. Okay. And I'm gonna order done. Here's what I want. And if y'all can't agree, don't let me hear a month from now, y'all can't agree on the order.
Write this down, I'll let you grab it.
Yeah, okay. I want her appointed as friend of the court to immediately search out and find the level of professional help that's available and the prices that are on it and the time periods that are involved, and get with the lawyers and the parties within the next 20 days.
Okay.
And that means that hopefully we'll have an agreed order in place by our May the 2nd rule day. If we don't, I'll just write something out of a whole cloth, as I used to say, okay?
Your Honor, I will tell them, this is something I haven't got to tell Mr. Cross about this place, Peaceful Solutions. They said they
It
can start.
doesn't do me any good to talk about these places.
I
I've
understand.
got a friend of the court you can talk to about. I don't know about any.
Can we tell her about these places
Absolutely.
and what
Both of
we
you can
found?
look up and suggest people and different sorts of services and what they call them. If they're Christian based, or if they, they worship the devil or whatever, anything that would impact how you feel about it.
Okay.
Okay, and then have her, and if y'all can't reach an agreement, then she'll make a recommendation.
Yes, I worked with her before.
Okay, there's where we are.
Okay, thank you very
We're gonna
much.
move on this sooner rather than later, okay?
Okay, sounds good, thank you.
Orton versus Orton. Pool versus. I didn't see this motion. You can file, is there a motion in there? What's?
Your Honor, this case came back for review. There was an order entered the last time in which we were going to review his visits. He receives visitation an hour a week, supervised by the aunt of my client. And the visitation occurs at McDonald's. We would like to report that out of 14 visits since the last court date, he's missed 10, and he was late 3 of the 4 that he did attend. So my client would ask that the visitation be suspended, or in the alternative, that it be once a month.
What do you have to say?
I'm filing a motion. I got a lawyer, file a motion for some different things. So if that's, we'll leave that up to you for now, but it'll be filed there shortly.
Okay, well, I'll suspend the visitation and submit me an order.
All right, thank you, Your Honor.
Thank y'all. People's Bank versus Olson Dalton.
Saves some time, Your Honor. We filed no response to the bank and are making no argument against their motion.
Summary judgment.
Just summary judgment and default judgment, asking for a motion for judgment and order of sale.
Okay, if you, paid, is it still $120 or you going to $200? That shows you how long it's been since I you paid you.
You get to pay online now.
No,
You filed, so yes. So yes, that's been paid.
You got to order those here outside of.
Thank you, and that's all I have.
Good seeing you, Judge. Thank you. Medical Center at Albany versus John Richardson.
Your Honor, we filed an affidavit to challenge garnishment and they withdrew their garnishment based on our affidavit.
They need to go domesticate the judgment and then take it down there is what you.
Well, we're trying to work it out, so.
Yeah. That was your defense, so that they hadn't domesticated the
That's
judgment.
correct. Yeah, we get that a lot. And a lot of times people honor garnishments out of state, but if they don't have.
Not if they have David Cross for lawyer.
Right.
Mid-South Capital Partners versus unknown heirs of various people.
Was hoping somebody would be here, Your Honor.
The unknown heirs are, do what?
Was it renoticed?
Yeah,
Where's it in the file?
I'm confused. Is it on there or not?
I don't know.
I couldn't take it off.
What happened?
It came in yesterday.
What came in yesterday?
The written notes.
Somebody renoticed it?
They said splendid news.
Unknown heirs and went again. VRB Capital versus WW. The agreed order was signed. Say on the docket. What is VRB Capital LLC versus WW?
Oh, that was the, structured settlement. Where they're trying to buy the structured settlement and they have voluntarily dismissed it.
Yeah, we don't do structured settlements here. I guess they file it somewhere else.
They just voluntarily dismissed it.
They learned you, Your Honor.
Yeah.
Or was that? He actually did take some.
Yeah, good. Steve Byer versus Gary Wallace. You filed a motion to remove,
Motion to expel.
yes, Mr. Wallace.
Yes.
You say that you've been denied due process.
Amongst other things, Judge, regarding J3 packaging.
Yeah, who didn't know anything about anything that was going on and had no relationship whatsoever to these other parties, correct?
No, that was not the allegations contained in our motion.
I just kind of assumed that's what you done.
But that certainly was not. It was more akin to, having yet filed any response to pleading in this case, that motion was not.
They hadn't been served.
They hadn't been served, nor had they filed their response to pleading.
Well, they hadn't been served, and then when they were served, then it's a little right. I will tell you that I'm very concerned about this case. I've watched it develop and all the relationships between the parties, and then I saw this attachment with this product that had been, created or manufactured by Cowboy, and then this other organization buys it and then resells it to Cowboy folks, and there's this big discrepancy, and I guess that was for packaging cost or something, very concerned about it. Now, is Cowboy closed down now?
Judge, that's just to make sure, we're talking about Dale Hollow charcoal. I think that's who you're referring to.
That's what I call Cowboy.
Yeah, that's not Kelly.
I misspoke. Somebody earlier today told me Cowboy was closed down, and I intermingled. Dale Hollow was selling it to an entity that was associated with Gary's sons or other people. Is that what was going on?
That's exactly what's going on,
Yeah.
Your Honor.
Yeah, I read it, just misspoke on the name of it. So now, when are you gonna file your response?
We have, Your Honor, we filed our response to Plea. Our argument before the court regarding the appointment of a receiver is that the motion was never renoticed, and that the motion to appoint a receiver was before J3 was even served with the complaint and had been a party to the action properly. And so we never had a chance to argue the motion.
Well, the receiver wasn't gonna be appointed over them though, was it?
It was, though. That's the discrepancy, and
I
that's.
thought it was just over the Dale Hall.
Your Honor, one, we had filed a motion for receiver and you said, I don't want a receiver right now. You said, I want someone to receive reports.
Yeah.
In order to review these reports.
Somebody in the same business that could review it. We never found anybody like that, I guess, right?
Well, we ultimately found someone, and what you said to me and Mr. Cross was, go back in that room and figure out what document.
Was there ever order entered to that effect?
Yes.
Yeah.
And we also came together and we put it on the record.
Yeah.
And Mr. Wallace, through his counsel, agreed to produce the records of Dale Hall charcoal. And he agreed,
And he did that?
No, and he agreed to provide these records on behalf of J3 Packaging as well. And then we had an order, that
You
was,
represent J3.
I do, and Mr. Gary Wallace has no ownership interest, has no operational control over the company, and had no authority to authorize those reports to be issued to the court on behalf of J3. He has no operational control.
That's owned by his sons?
Owned by his sons, wholly separate entity, wholly separate operating,
Well,
completely different
That's
business.
that's your position.
That is
It's
our-
hard. It's hard. That's what your position's supposed to be. It's hard for me to believe that there's not direction from Mr. Wallace as to what's going on with those people. And if I was the plaintiff in this case, I would be very suspicious of that, tunneling, is that what you call it?
yes, Judge.
Yeah, I'd be very suspicious of that.
Your Honor, Mr. Wallingford indicates we did not furnish the records, and Ms. Fields, who's had the discovery on this, says we have supplied very substantial records to them, and I don't know if there's ever been an exception taken as to what you didn't get.
Well, those are two or three different issues. And one, we
I'm
serve.
trying to get my arms around all of them. I forget from one time to the other here. Who's on first on this deal?
Your Honor, you had ordered effective, and I believe this was in February of 2024, this year, the reports were to be provided to the board. That is the accounting firm on behalf of both J3 Packaging and behalf of Dale Hall Charcoal. None of those reports have been provided to Dean Norton Ford. That was something that arose as a result of your order in light of that motion for receivership. What Ms. Fields and Mr. Cross are discussing is their response to discovery requests, which if I can go back and you can recall those as well, I served discovery responses about to them. They didn't respond and moved to compel. They provided a small sample of.
Well, so there are two different issues there.
And it's not really-
Let me ask you, are there two issues? What went to Dean Norton and Ford, and then what you expect in discovery? Those are two separate issues.
Yes, Your Honor. And the issue before this court was what's had gone to Dean Norton and Ford.
Yeah.
And at that point, nothing's gone to Dean Norton and Ford pursuant to this court's order.
What do you say about that?
Your Honor, I forget exactly what that was entered, what, latter part of February, Mr. Wallingford, the order, or?
I think it was, I can go, I've got the word.
I think largely some of that's been miscommunication between Mr. Wallace and I regarding what he was supposed to furnish. He was.
So we need to keep this separate here about the discovery request and what's necessary for Dean Norton and Ford. So let's just talk about Dean Norton and Ford. This exhibit that you sent to me that showed what Dale Hall had sold to the subsidiary and what the or to the packaging group, I'll call them for the lack of that, and what they had sold to someone else in a discrepancy of about $600,000 between the two. Now that's something that bothers me right there. Now, I don't know what it cost to actually put that in various packages. I guess that's what your clients were doing, were they putting it in packages?
That's correct, Judge.
Okay, and what they were putting in packages and what the markup was, and selling to people that were previously clients of Dale Hollow raises at least the specter of something inappropriate going on. And I'm not going to ask you to agree or disagree with that, but I mean, that's a flat fact.
We would contest that fact, though.
Then what, well, of course you would, or we wouldn't be here if you didn't contest it. But I don't see how does it cost 50% of the value of that charcoal to package it? Is that how much it costs? I mean, it looked like to me, the major portion of the cost of manufacturing charcoal would be obtaining the wood and burning the wood and putting chemicals on it or do whatever, and then you can sell it to people to package it if you were so inclined. Was Dale Hollow ever packaging it themselves?
Your Honor, the
Yes or
answer
no?
is no. But one, J3 Packaging is selling to two customers. One they're packaging for, and one they're just shipping the exact same truck. Passing it through.
Yeah.
Shipping off that exact same truck of charcoal. So there's two customers out there.
But again, these are some, I believe Mr. Wallingford and the plaintiffs here have taken some issue and some umbrage with us making blanket statements regarding the lack of any business relationship between Gary Wallace and the boys who I represent under J3 Packaging. He's making blanket statements about only having two customers and only these facts are going to be established. Yet, this is what needs to be developed in the record. And the reason why we filed our motion to vacate.
What did you say?
And that's the reason why the record needs to be developed.
No, right before that, what did you say? You said they were making allegations that there were just two buyers, and then you said something, and then you went over what was in the record.
Yeah, these are fact statements that are being made by the plaintiff. And they took umbrage with our statements about there's a lack of business relationship between J3 and the only business relationship would be a distributor and a supplier or some down chain supply chain relationship. There is no operational control by Mr. Gary Wallace. There is no ownership interest. These are on totally separate operating facilities. That's been developed in the record that we have already.
Where is it been? You don't have any record. You hadn't been involved.
We're just now getting involved, and that's the reason why we're coming to the court.
Developed in the record.
There has been some depositions taken. There has been some recent discovery taken and some depositions.
Since you've been involved?
Since I've been involved. In the appointment of the receiver, the order of it was right in the midst of us getting that discovery going. The motion that the order that was entered with regard to the appointment of the receiver on behalf of J3 was entered without any renewed motion. It was just entered.
I don't want to talk about a bunch of procedural things with you. I understand that you hadn't filed an answer, and you've got a right to file an answer, and you've got a right to put forth in your thing. But, this is not Jefferson Circuit Court business court with me. Okay, I don't do a lot of these things, but I will tell you that I'm not going to be cut down for the rest of the month talking about this motion and that motion and this motion and that motion. I want to get to the facts of the case to see if there's ultimately anything that goes to a jury. And I'm going to tell you, I'm about a half a second from removing him. I'm about a half a second from removing him because I don't think that anybody believes that there is no connection between sons and fathers when it comes to a business like this, unless there's a pretty tough, there's been a big falling out or something like that, because I'm sure those young men know what they didn't know because of the expertise their father has.
May I address the court briefly in that regard? Your Honor, Dale Hollow wasn't doing packaging. They were selling in bulk. These brothers who were grown and very intelligent people.
I have no doubt about that.
The idea was we need to package this ourselves. It was done with Mr. Wallace's blessing, probably with his encouragement, but it's a completely separate facility. So now the profit that somebody else was making for packaging is being made by the boys. And yes, it does take a lot of money to do packaging, and If, Gary Wallace can tell us more about the charcoal business than anybody in Clinton County.
I have no doubt about that either.
He can, and he can run this business, which is all the more reason not to remove it, because he'll see that it makes money. But this was something that wasn't being done, and now
Do you think that if they were going to do that, if they had any obligation to offer that business opportunity to their partner, their cooperator, or could they go ahead and have somebody in their family set up a side deal and pass through this charcoal without packaging it and sell it to somebody else, or start packaging it without giving the opportunity?
A good point, but
Well, thank you.
I believe that the sale price was comparable, what was being sold to these third parties, so there's no detriment whatsoever to their.
Here's the thing about it that bothers me. There might not, maybe they were paying what the third party people, but maybe it was worth more than that. So does a partner take that opportunity themselves and leave these other people standing in the dust? Do you have any problem with that concept, that your people get left standing in the dust?
Well, absolutely.
That's what yeah.
49% owner and the number one creditor to the He's got a significant amount of money wrapped up in this thing. And I would add that he is also somebody with significant engineering and manufacturing experience. He was also involved in Del Hollow Charcoal 2 years before they had this falling out. He got locked out. In addition, he's been involved in federal manufacturing for the U.S. government and the United States military for, I believe it's about 20 years. He's an engineer.
How about Mr. Wallace?
Mr. My client, the minority share.
Mr. Wallace got some expertise in manufacturing things too. He might not have had the same. So,
I don't mean to disparage his expertise as well. I'm simply saying that if Mr. Wallace, if you're.
Well, the question is, if you got a 51-49 and you're in a venture together and you see a way that your product could be sold at a higher price, or if you went into packaging the product, you have a responsibility to offer your 49% partner an opportunity to participate in that, or do your sons go into the thing and you start selling product with them? And obviously, if they're buying it for the same price and that they were previously selling it for, the haul was, and yet they take that raw product and sell it to somebody else at a higher price without packaging, that brings up a problem too. So I don't know. I would think that at some juncture that this thing might be ready for mediation. Have y'all tried mediation? We talked about mediation.
We've talked about mediation before every single motion, Judge.
Yeah.
And we've been before you since, I think, the complaint was filed in April of May 2023. And so there's been a number of
I always look
discussions.
forward to seeing all you guys. I just don't have an answer to the problem when there doesn't seem to be any inclination to work this out, or any recognition of why a major investor into something would feel like they had been wronged if this happened. You understand how somebody would feel wrong, Mr. Cross?
Your Honor, I do, and then there's, that's where it gets really, really complicated. I understand the question. I think it could be answered. And another question I do want to answer based on Mr. Wallace refreshing me is, he and Mr. Byer discussed packaging initially, and Mr. Byer didn't want to do that. So that's why subsequently this decision was made to do the other packaging. And now regarding mediation, we have asked Mr. Wilkers
Let me ask
and
you
Mr.
something.
Walker
Let
to
me
go into
ask you
mediation.
something.
Yes.
What legal obligation, this was an LLC with two members, right? Right. Okay. What, and your client owned 51. What obligation does a 51% owner have to a 49% owner to let them participate in this new avenue of revenue before going out and setting somebody that's closely associated up in the business to do that? Doesn't that cut to the chase on the whole thing?
And I think that.
Does that cut to the chase?
Yes, you're right. And I think the answer is absolutely none, as long as it's not to the detriment of the ongoing business. As he says, he asked if he wanted to go into packaging. That's what Mr. Wallace says. Mr. Byer may disagree with that. But I don't think he's the majority owner. And I didn't set this thing up. None of these fellows had, when they set this up, they didn't have representation that was, sufficient. And, that's why we're in such a mess.
Sounds like something I would have drawn up, so.
Well, maybe Darryl Coffey or somebody like that in your office, I don't know.
Well, and I'm happy to address, we provided an operating agreement, and we think that that's a basis alone that's in there to indicate that they would be expelled. There's lots of provisions in there that indicate that these guys have joint control when it comes to these decisions. So Mr. Wallace is simply taking a lot of these decisions up on his own. But back to
Which decisions? Let's don't go to something else.
pricing, customer selection, things of that nature.
And whether you expand to packaging or whether you sell a raw product to someone else that they can mark it up and sell it to somebody else, all those sorts of
Well,
things.
I would certainly believe that. Pricing and customer selection certainly had a big part of this. And one of the easiest way to look at this, Judge, is one of the two customers, Humphreys Charcoal, is they're buying product from J3 Packaging. And this is the customer that's simply getting charcoal, Dale Hollow charcoal, that's driving right past J3 Packaging, which is on the exact same property, directly adjacent, and they're going straight to Humphreys Charcoal. There's nothing being done to this product. It's not being packaged.
And yet J3 takes ownership on it somewhere from the drive from here to there and does a markup on it. Is that what you're?
Well, it takes ownership of the money at some point. I don't know. I guess there might be a theoretical ownership. There is invoices that transpires, but there's no way, there's no mechanism to weigh even what's being purchased.
The problem with Mr. Byers' argument, though, is that they get paid for the purchase of the J3 buys the charcoal off of Dale Hollow charcoal. So J3 Packaging
passes by, and whose truck is it going in?
Well, this is a Humphrey
truck.
Humphrey Charcoal.
So Humphrey Charcoal is going over to Dale Hollow, picking up charcoal and delivering it to Humphrey's.
They're getting it from J3.
Humphrey's plant. And then J3 builds it.
They're getting it from J3.
Does J3 ever have possession of it?
They do.
Where do they take possession?
They have a wholly separate entity there.
They have
a wholly separate operating facility there
So it's transferred from Dale Hollow, the product itself, over to J3, and then Humphrey picks it up from J3.
That's my understanding of the business operations, and I can't.
Well, Your Honor, the real estate is very convoluted because, and that's to put it lightly, there's an installment land contract that was never executed between Mr. Wallace and Mr. Wilson. Me and Mr. Cross were talking about this installment land contract. We never even provided a copy of it. We were provided statements as to what the installment land contract would be, what it would cost, and those haven't matched up with the draft of the copy that we've been provided. Nothing's ever been signed. So when J3 Packaging went to start up, they just went into a building that it was our understanding that we actually started operating. So the brothers simply started this bagging operation. They use the exact same address. In fact, if you trace the invoices of this, it's
how much money does your client have?
My client has about $1 million into this business.
And Your Honor, he'll get his money back for the most of it if this business continues to operate under the management of Mr. Wallace. That may seem far-fetched, but
It doesn't seem far-fetched to me. Somebody's making some money on it. Would your client sell out for what they have in?
Your Honor, as far as this.
You don't have authority.
I don't have any sort of authority.
If I get my $1 million back, I'd head back to wherever I came from.
Your Honor, Mr. Wilkerson's clients and possibly my client want to try to get this settled, and it's not going to get settled unless Mr. Byer gets a substantial amount of money back. That's why I think this matter needs to go to mediation immediately.
Well, I think the only issue to be developed here, I think the facts are fairly clear. There's some documents that made unclear that weren't that weren't signed as far as the ownership of stuff, and you've got somebody that's coming, Mr. Cross, could you just give me the courtesy, give me just a minute? I know it's hard.
I know, but
I know you're excited.
no, what it is the signed copy of the agreement is outside, Mr. Walford, and it'll be brought in here in a minute for you. Okay? You're saying it wasn't signed. I thought we furnished that to you. So that agreement between Wilson and Wallace is going to be in your hands today. That's pretty good. Sorry.
Well, we've got the ownership of property and you've got all these places at least proximate to each other, and this product that's been manufactured, it comes into the hands of the ownership of J3 and somewhere in Soda Humphreys, which is over there near there. And Del Holla does not get the benefit of that sale, but 51% owners' sons do. Well, who gets the benefit of it then? J3, who owns J3?
Who owns J3? Jared Wallace and Jackson Wallace.
Who are the sons of Mr. Wallace.
Your Honor, they basically they become the middleman. That's what it amounts to. That's what it
I
is.
know they've become the middleman, but there's not much difference in the middle.
We take issue with that because there is a wholly separate product that Del Holla did not do. They are a packaging facility out mainly, right? They package, they have a unique customer that had never been a customer of Del Holla before. It's called Blues Hog.
Well, no, at Wallace, we were talking about.
Yes, that's correct. I'm saying that Del Holla Charcoal never had the customer that we're talking about, Blues Hog. And so that's J3 Packaging's bread and butter, so to speak. That's their customer who they package charcoal for, unique bags, unique packages.
Same product that's made over at Del Holla.
Well, no, it has to be shifted, it's sifted, it has to be packaged in an appropriate manner, it has to meet their standards under the contract, the unique contract that J3 has with Blues Hog. There has to be, I mean, they have standards that they operate under. And so no, this is not a siphoning a client from Del Holla. Del Holla never enjoyed the business of Blues Hog. Blues Hog got into business with J3 specifically, entered into contractual relationship with J3 specifically. And Blues Hog is J3's primary customer. And so that is who they have been dealing with. And so this is not a middleman relationship. This is a unique business in and of itself.
I thought Mr. Cross said it was a middle.
That's what again, yes, that's correct. That's what he's saying, but we take issue with that.
Hurts your case a little bit.
Well, we just take issue with it. It's not.
Your Honor, there's a difference in selling bulk and selling packaged. There's a profit therein. I refer to that as the middle.
Well, I'm sure there is. Sure there is. Is it double?
Your Honor, I think one thing I would also add, you asked for the owners were of J3 Packaging, one of those gentlemen, Jackson Wallace. He's also continues to be employed to Del Holla Charcoal. And he is actually responsible for invoicing Del Holla Charcoal. He prepares invoices that he then sends to J3 Packaging. And then on behalf of J3 Packaging, sends the money to Del Holla Charcoal. So the conflicts of interest here are overwhelming. And the specter,
I don't do many business cases. I had some wonderful uniform commercial law courses in law school with Professor Leibson. I made a lot of money on the uniform commercial code, various aspects. But it got back down to something. Some things just aren't right. They just aren't right. And people that are involved in them think they're right. They might think they're not doing anything wrong, but you get these LLCs. There are all these controversies in America now where people have all kinds of LLCs and you can't prove whatever they do. And then you have a couple of legitimate LLCs over here and people criticize them because of everybody else is abusing the LLC. I would like, who is the mediator that y'all would?
I've asked Mr. Wallenberg to tell me who he wants.
Well, they got the business court. Jefferson County, I don't think, but they have a business court.
Your Honor, I have never stepped foot in the Jefferson County Circuit Court.
Well, I know, but.
I'm a Bay County.
I know, but I'm telling you, you're aware of the business court. Are you aware of the business court? It's a specialty court that they're trying out in Jefferson County, just like drug court or some other things. And they've got a few judges up there that have expertise, maybe background like that. I could get you, former Chief Justice Minton to come over and try to mediate the thing. I don't know what kind of background he has in business law or things like that. We could get former Judge Phil Patton, who was a tremendous judge. That sort of thing. Those are the people that are most approximate.
I did a, just the court's aware, my first felony mediation was Pat last week, and I was very impressed. This is one's mediator, he's Scott Backer.
Who?
Scott Backer, both of us, who is just, he's trying to slow down too, I think, but.
Is he a certified mediator?
I don't know if he is, but he could be. I don't know if you know Scott or not. He's done nothing but business law. Been in bankruptcy for many years.
I mean, Judge, I can come up with 5 or 6, just to take it down.
Who would say Candace?
Rob Duncan is one, John Hayes, they're both guys that have a lot of experience in kind of industrial related litigation, the way I describe it. I recommend them a lot. They're with Kincaid still, so I recommended them a lot for construction discipline between general contractors and subcontractors. I've used Lee Gamble a whole lot recently. Lee Gamble's.
He's excellent. I've used him.
Lee's absolutely excellent.
Well, let's try him.
That's fine.
And I'd be happy.
He's got like I know who he is. I know him. Might have done one with him years ago sometime that didn't work out well, but that's not because of him.
Your Honor, if Mr. Wallingford wants to make the arrangements, I'm gung ho to try.
Let's, once you get up an agreed order, that I'll appoint him to enter into mediation, and if he's available to do it, let's say the next 30 days to start it, then he'll get a list of all the information he wants and what he wants to hear from your clients and where they can prove how really a separate entity that they are. I'm not saying that they aren't a separate entity. I'm just saying how it appears from the outside. If I was in this situation, what I would look at and all these indicators with one of the guys still working over there and him doing the billing and stuff, it's not a good way to do business if you're trying to avoid getting sued. It's not to recognize all of those potential conflicts that you have with a lot of people would be suspect. So, is there any other immediate discovery you need before you go to mediation?
Well, the pending issues before the court really relate to what I would call this kind of interim relief, which is providing the reports to Dean Norton Ford. And then there's also this issue about who's going to manage the Alcohol chargeable prior to mediation. What I'm hearing you say is go to mediation and come back if you can.
What I want you to, the Dean Norton and Ford issue needs to be rectified.
We'll get that done next week,
Okay,
Your Honor.
and you need to give Mr. Cross explicit information that you want provided to Dean Norton and Ford.
Yeah.
Exactly what you want them to have, and I expect y'all to do that.
And the order says that to that effect, but then this discovery issue is a separate issue as well.
That's exactly right.
And we've provided them with a letter to that effect also. Yeah, I'm happy to.
Okay, I want to do one thing at a time. I want the Dean Norton and Ford thing.
Sure.
Now, after you do that, then you tell me what other discovery that you'll need in order to feel comfortable going to mediation.
Certainly.
What is that? What is the?
Well, it would be whatever the information that is contained within our, I think it's like December 26, 2020.
I'll need an explicit list of what you don't have.
Certainly.
If I'm going to order them to provide it. Now, do you need anything from J3 packaging that you don't have?
Just those reports go to.
And of course, that's the motion for review, Judge, with regard to our motion vacate as it pertains to J3 and the necessity of them having to provide anything to Dean Norton Ford with regard to their business operations. I mean, like I said,
Well, they're going to have to provide.
Okay, and so at this point, the court has denied our motion to
That's
vacate.
right. At this point, that's the operative words.
Right.
Okay? And I'm not, you can tell your clients that I'm not prejudging them or supposing they've done anything. The information that will speak for itself, because you have to have all that information. And so I want you to give them an explicit list of what information you want from them. Okay, and then we'll, and I guess you'll contact the mediator and copy a letter back to these other two counsel, telling that it's been suggested here that he enter into this mediation.
Your Honor, I will personally try to arrange my schedule to accommodate the mediator as soon as possible, and I know Mr. Wilkerson would make that effort as well. His fields can handle my office per day.
Well, you think there would be facilities available at the Gatlinburg Inn?
Well, it's conducive to people coming to agreement, Your Honor.
You put them up there into the, Tennessee's.
The Rocky Top.
Rocky Top.
Room 388.
Yeah, that's where Rocky Top is.
Your Honor, we could probably come to some sort of accommodations in Somerset, maybe.
That's midway, that'd be fair.
That's midway.
Wilkerson has a fine office.
I could probably speak with Mr. Hatfield, Mark Hatfield, county attorney.
Well, I mean, and you might go up to Clee's place up there. You know, they're set up for mediation.
Where's that?
Lexington.
We probably need to come to Somerset. I don't think he's got those accommodations, but we can figure out something in Fayette County also.
Okay.
If it need be.
Well, there's some empty offices over in the basketball complex over there. That don't feel like they're gonna be filled.
Well, they're gonna break my heart out.
Yeah. Yeah.
There is Wayne Carter, I don't know, let's see what happens.
Dan Hurley's not coming, so that's no surprise.
Drew's not coming either.
Martin Cross is available, but that's.
Okay.
And what, so I'm clear, our motion, I guess, is passed.
Held in abeyance. I'm not gonna,
denied. And then
but I'm gonna tell you, if I don't get some, if I don't get some assurance that everyone's coming into this negotiation with clean hands and a pure heart, I will do something that probably not be happy with people, but no. That's what everybody needs to reflect on their actions and come into this with a clean hands and a pure heart. And put yourself in the situation of someone who has invested a lot of money in your place and see how they were treated. And on the other hand, if you fully feel like that this was a separate and justified deal and you offered the opportunity for your previous investor to participate and they turned it down and you can prove that's part of it too. I mean, I'm open-minded about it.
Thank you.
Okay, thank y'all very much.
Well, I'm prepared.
Okay, thank you. Okay, what else we have? It was passed over to our drug use.
It is.
Withdrawal.
We're gonna withdraw its notice for Monday.
That's all I understand.
This is on it.
Tabitha Malafano and Jonathan Rogers. Who do you represent in this thing?
Judge, this is a petition filed by,
Who do you represent?
Tabitha Malafont.
I represent Mr. Rogers.
Where is Mr. Rogers?
It's at work, Your Honor. He was not able to get off to be
Well,
here.
where does he work? Here in Clinton County or?
No, he works out of town.
And you want to file a late response, is that correct?
Oh, well, actually, I've actually already filed it, Your Honor. Right, get that to you, get it signed. The only reason I asked for the
Was
extension,
it late?
it was late, Your Honor.
Well, then you have to have permission to file a late response.
Oh, sorry, that I'm asking permission to file a late
Okay,
response.
that's what I thought I said. Maybe I'm not clear all day today. That makes no sense. It's okay. Now, what's the issue here?
Judge, the issue in this case is, the child has been withheld from Tabitha for 3 months. She hasn't seen the little girl in 3 months. He doesn't even work in Clinton County and isn't in Clinton County. The stepmom has the girl and
Who's stepmom?
Mr. Rogers' wife. And she has simply been unable to get the child. We were unable to serve him because he's not here.
They were never married.
They were never married.
And how long have they been, were they ever together? They ever cohabitate?
How long?
We were together for like 8 years.
Okay, well, how old's the child?
She's 8.
How old?
She's 8.
They've been split up for some time.
Yeah.
Well, what is sometime?
3 or 4 years.
2017.
That's some time. That's 7 years.
Yeah.
So they separated when the child was 1. Hey, did they ever have visitation?
They've never had a custody action. She always had the child and the child lived with her until
when?
April
Till
of
when?
last year.
April of last year, and then what was,
There was a juvenile court action filed against her, which was subsequently dismissed.
about what?
It was related to abuse of the child.
Whipping the child?
Yes.
Starving the child?
Whipping,
Whipping the child.
yes.
And.
It was subsequently
And then
dismissed
the
by Judge
child,
Lloyd.
the child was temporary, was placed with the biological father.
Biological father and or grandma, I think,
And then it was
yes.
never delivered the child back.
Yes.
Okay, now, what was your class position?
So to add a little bit to that, whenever the case was dismissed.
Yeah, will you move over behind?
No,
me?
you're all good. So to add a little bit of context to that, whenever the juvenile case was dismissed, the parties were directed to see if they might be able to come to some sort of arrangement on custody and visitation. Prior to my involvement, the attorney that was representing Mr. Rogers had presented an offer for equal custody, joint custody, equal
Who was
visitation.
that?
I believe it was Ms. Blevins. that
Yes,
represented
and
him.
King, she had her baby,
Or sorry.
about 3 or 4 days ago is the reason I think she's not involved in it.
And so from what I understand of it, my client had reached out with an offer of that equal arrangement that was declined. My client indicated that he's not opposed to there being some sort of arrangement, but it needs to be an official arrangement on paper because the
That's
concern.
always best.
Yes, exactly. Because he would have no recourse in the event the child was to be taken and not returned. Also, he had concerns beyond just scheduling. This abuse issue is not something that's new. There had been a previous issue with a paramour that's still in the home who was.
Little boy or little girl?
I'm sorry?
It's a little boy or little girl?
It's a little girl. There was a prior issue of abuse by a paramour. He's currently on a diversion in circuit court from here. My
Is
client
he
also.
still involved?
He's still in the home.
He is not in the home, actually.
Well, it's just
Is he in the courtroom or?
He is here, but that's like a meeting.
So my client has more concerns than simply, I'm not letting mom see her child. From what I understand, the parties had a good period where they were kind of working together. There are
Okay,
concerns.
well, I'm not gonna send this to the commissioner. I'm just gonna hear this myself. You got your calendars with me?
Yes, sure.
Is there any discovery or anything, or y'all need some time to get witnesses?
I would just need to gather some records from these, there's a couple of agencies that were involved and some court records. I need to gather those, but I believe that'd be the only discovery.
Okay,
Judge, we won't need a whole lot of time for anything like that.
okay.
The only thing else that I would mention is there is information from the child that I think is pertinent. I would ask that there maybe potentially be a friend of the court appointed just to receive information from the child, so we don't have to bring the child in here to do that.
Judge, I don't have a problem with that. My whole issue is getting her something immediate, because it's like I said, it's been
Well, we'll
3
get to
months.
that in a minute.
Right. I don't have a problem at all with friend of the court.
That's, you know, instant coffee ruin the world, man. You gotta let things perk sometime, okay?
Yeah.
Okay. And we're not talking about a long time from now. These cases here was canceled. And this one. This one's going good.
Still on this one. It's like another version.
And this one.
No. Which one's the Proceedings? So, I was saying, she.
Is that?
She's.
Yeah. So I can do it on 29th.
Yes.
Monday, April 29th.
I have a matter in Wayne District that day. Is there,
It's something you could reschedule possibly. How often do they have district court over there?
well, they have it every Monday, but I'm the assistant county attorney, so I participate in all those. If you have maybe if there's no other date that we can make.
Well, there are some other dates, but this is the most immediate date that's open. You know.
I can make that work.
Okay. Start at 9 a.m.
That's no problem.
Now, I would suggest that we probably have this Cumberland County instead of here because of facilities. Do they have court here on Mondays?
Yeah.
So we can have the facility. Okay, we'll have it here. If y'all know they have it.
Would be preferable.
Either way.
Be fine. Yeah, I want to enter a friend of the court order today. Since she's doing that other one, just put Holly Long Parish into it. And let me see here. Now, there hasn't been any visitation going on, right?
Not since January, you're on.
Yeah.
And prior to the close of the juvenile action, it was every other weekend, and I think so many hours during the week, like one day a week, there was so many hours, and then every other week.
Was your client amenable to doing anything?
Yeah, I mean, he would like to start with that, Your Honor.
Judge, they've already offered a speedy.
Well, give me a break. Okay, let's talk
I'll
about
start with
something.
whatever, I just wanna.
Yeah, let me get her some visitation immediately that's agreeable, and then you might get to 50-50, or you might get more than 50-50. I don't know. I'm open-minded about this, you know what I mean? But how much was it beforehand?
It was right at the close of it. It was every other weekend, and I think so many, I
It
can't
was a
remember.
Wednesday, like an hour and a half.
Well, that's not enough. Okay.
Well, no, it was every other weekend plus the hour and a half on Wednesday.
Okay, well, is child in school?
Yes,
Where's child go to school?
Albany Elementary.
Yeah, and where?
She's second.
You live here in Clinton County?
Yes.
And your
He lives-
client lives here in Clinton County?
I think they're pretty close together, actually.
Okay,
live
well,
actually
let's
on
do it every other weekend and every Wednesday night. Okay, now, you have an objection to someone who had being present during those visitations?
I do at this time, Your Honor.
Well, that's what we're talking about on a temporary basis. Do you cohabitate with someone? Someone live with you?
Just my daughters,
Okay, well.
other two daughters.
Okay, well, there won't be any male there
Yes, sir.
on the overnight visitations, okay? I'm not prejudging any male. I'm not saying anything about anybody, but out of abundance of caution, especially when there are little girls involved, you know. One of my worst nightmares is to put a little child somewhere, you know, when something happened to him. So, okay, so you draw up an order to agree to that, and where do you want the exchange to take place? Children.
Where have they been doing that?
They live right next door to each other.
They could probably.
Send them across the yard.
Yeah.
I think so.
I think the child
I think it's walking up a hill.
Okay, well, let's, I know things happen, things change, that sort of thing, that I get this, friend of the court thing issued right away. And hopefully we can move toward reaching some accord where we won't have to have a hearing where people say bad things about each other that are never forgotten. You know, I mean, that's what happens in every hearing. Even when you start out not to, it just goes in that direction, in my experience. Okay? Thank y'all very much. You're gonna draft it, get him immediately. If there's some problem in drafting, I don't want to hear about it next month. Got some disagreement, both of you call me on the phone and we'll get down to it.
Judge, would it be okay if she has this weekend, since she hasn't seen the child in several months?
It's okay.
That's great.
All right.
I guess that would be the only.
Friday at 6 and Sunday at 6.
How old is the child? She playing like any bowling and something?
She was in gymnastics, but I don't know if they changed anything.
I can check with him. To be frank, I didn't ask him about the child's extracurriculars. So
Okay, well, if there are extracurriculars, make sure that the mom gets to deliver the child extracurricular, because they don't want to hurt the little child's feelings by missing something, you know?
Right, sure.
Okay, thank y'all very much.
One last thing, can I ask you, do you want any sort of like pre-hearing documents, statements, any sort of things like that? I just want to make sure I don't miss that.
I don't, if you think there's anything that is helpful, but yeah, it doesn't seem like to me there's a lot of documentation.
I just didn't know if there was like
Well,
issues or summaries or anything to that effect.
I'm willing to just let them labor it, Jesus explains them, you know? But y'all need to be candid, y'all need to be candid with, a friend of the court.
Yes,
make
sir.
the child available, and then both sides say what their problems were or anything, I think, okay?
Yes, sure. Thank you.
Okay, thank y'all very much. Next thing on the docket.
Matt and I were here on a case last docket day, Brandy Young, I was appointed to represent her, she's in federal prison. I wasn't sure if they could add on the docket or not.
Why don't you get his attention?
You know the Brandy Young case is on.
I thought the judge had mentioned put it on today, but it wasn't on the docket. They bring it forward, basically.
Well, I just would report though that I found out that she's in federal prison in
Do y'all want to
Tallahassee.
come around here and get on the record here if there's anything I need to know? Just cite the name of the case.
What's your,
It's Joseph Young versus
Brandy Young.
Randy Young.
I was appointed for Brandy. She was previously in jail in Grayson County or somewhere. Now I've just learned that she's in federal prison in Tallahassee, Florida. I have,
No, no.
yeah, so her estimated date or the date that she's to be released is late 26, I believe. So I have reached out to the prison system. They're going to have someone else to get in touch with me to set up where I can speak with her. What I had asked Mr.
What are you trying to do in the case?
Finalize it, basically. We just want, it's a divorce. It's kind of been lingering for about a year. We just want some kind of property settlement. It's one of these things, they've been separated for 8 years. No property.
There's children.
There are children, but of course she's in federal prison.
What I had asked Mr. Garman to do is if he could send me a proposed agreement when I get that meeting set up with her. I was hoping I could email that to
Well,
her.
federal prisons are pretty good about allowing visitation, aren't they?
They emailed back directly and she said she would have the other lady to contact me to set up a phone conference. So I was thinking if I had an agreement to send to her.
Well, I think that's an excellent idea. But
I'll be happy to
I would like, I have no experience with that, to see what sort of visitations that are usually appropriate, considering the travel distance and everything like that, and what federal prisons, they have some places have areas where people, actually spouses have conjugal visits and things like that, some of it, I thought, you know, but now I wonder if they have a place where someone can be with their children privately too.
I'm not sure, Your Honor, what she will request, because I had email contact with her when she was in the previous detention center. She never would reply or respond, because they would set her up an email account.
Okay, well, now, do you have a motion to terminate her parental rights, or you just want to get this?
No, Your Honor, I'm not sure. We could consider it, I'm not sure it'd be appropriate, since it's basically incarceration alone.
Well,
the case.
it is incarceration alone at this juncture, but if it appears that she doesn't want to have anything to do with the children or that sort of stuff, I mean, she could have some good reason, like, I don't want them to see me in jail, which ends that. Right now, it's incarceration alone, but it could very well be that there are other factors in the desire not to see them, that you'll have to.
Yeah, and I don't know that, but what I was also wanting to ask, do you want me to ask when I do have contact with them, if we can set up a Zoom hearing if she doesn't sign an agreement?
Yeah, sure.
Well, that's the only kind of hearing that you're gonna have in the federal
yeah.
court, because they won't transport anybody.
But I could see
You're not
if,
willing to travel down to Tallahassee?
I've been there before.
I could see if they'll entertain that
As a
though.
matter of fact, I'm on the verge of becoming a Florida State fan. So.
Good luck. Good luck.
Oh, getting a Zoom hearing?
The fan.
Has it been
We've
problem?
been dealing with them in the federal.
Let's just hope she signs the agreement.
Yeah,
I
so.
mean,
if
that's
it's
what I'm
agreement-
saying, you can't expect, I mean.
Yeah,
So
And
they
there's nothing-
say that their partners using the federal system do not allow them to use it.
Yeah.
So, yeah, it's just a,
And if they can do something else like teams or anything else,
Anything.
I can figure out any.
okay,
So,
okay, I'll see if that's an option if she don't sign anything.
Okay.
I'll grab something and get it to you.
Okay, thank y'all very much. That ends the day of court here. Thank y'all.